All right. So, welcome everybody. This is part two of the Obligations and Contracts lecture. The first video was on obligations, and in this second part, we will talk about contracts. Now, I'd like to thank everybody who's watching the live stream, and also everybody who would watch this after the live stream. So, if you're new to the channel, I'm Attorney Al Jumrani. I'm a law professor at the University of the East, among other law schools, and I made this lecture video primarily for my students at UE Civil Law Review 2, and also I'd like to share this for the bar reviewees, law students, and just about anyone who wants to know more about the law on contracts. Okay, so if you're new to the channel, please consider subscribing to my channel and please click that notification bell so that you will be notified in case I upload a new video. Ayan. Okay, so last video or last lecture on obligations and contracts, I left some questions, and I think the students who gave their answers in the comment section. But my take on those questions are as follows. So previously, I gave these questions, and so I will now read them and also answer them. So remember, the first question was, Attorney Campos was one of the incorporators of ABC Corporation. From 2005 to 2010, he was the president and chairman of the board. In 2010, he sold majority of his shares and became a minority stockholder. He was not elected to the board but was permitted to attend the meetings by the former chairman for his significant contributions to the company. During the stockholders meeting in 2017, the board was reorganized with a new chairman and new directors. Attorney Campos went to attend the first board meeting but was denied entry. He insisted, claiming that he has the right to attend and the board obligation to permit him to attend. So what are the sources of obligations? There are 5 sources of obligations. We have the law, contract, quasi-contract, quasi-delict, and delict. Okay, so everybody knows that, and it was also discussed, or these sources were also discussed in the previous video. Now, in the case above, does Attorney Campos have a right and the ABC Corporation's board the obligation to allow him to attend the board meeting? Explain. We said that obligations must be sourced from any of the sources of obligations, whether it's law, contract, quasi-delict, or delict. And if there's an obligation in favor of a certain person or a certain party, then the other party has the right to demand it. Now, in this problem, there was no right to demand that obligation because Attorney Campos was not elected to the board. Under your corporation law, a stockholder may only be allowed to sit in the board if he is appointed in the stockholders meeting or in the annual stockholders election for the board of directors. So that's why, since there is no right either granted by law, contract, quasi-contract, or quasi-delict or delict, then there is no obligation on the part of the board to allow him to attend the board meeting. And so that is the answer to this question. Now, the second question is, Julius opened a savings account with XYZ Bank in 2015. In 2017, he applied for a housing loan from the same bank. Last year, Julius defaulted. XYZ Bank then applied the balance in Julius's savings account to pay for the amortizations of the housing loan. Julius questioned this, claiming that he did not give his consent. So, question, what is compensation or set-off as a mode of extinguishing obligations? Well, we learned in the previous video that compensation or set-off as a mode of extinguishing obligation cancels out concurring obligations of two persons who are or two parties who are creditors and debtors of each other. Now, we have to remember or state the requisites or elements of legal compensation. So aside from being creditors and debtors of one another, the obligations must be in a sum of money, and also the obligations must be due, demandable, and liquidated. And lastly, there must be no dispute or any legal issue involving the two amounts to be set off. In this case, so in the case above, was XYZ Bank correct in applying compensation or set off? Why? Yes, XYZ Bank was correct in applying compensation or set off because XYZ Bank was the creditor of Julius as far as the housing loan is concerned. Julius, on the other hand, was the creditor of XYZ Bank with respect to the savings account which Julius had with XYZ Bank. So we said that the law that applies to bank deposits is the law on loans. In other words, it's just in the name that it is called a bank deposit, but technically it is a contract of loan. The relationship between the depositor and the bank is that of a creditor and debtor. That's why the bank pays interest for the use of the deposits of the depositor. So because the elements of legal compensation are present, thus XYZ Bank was correct in applying compensation or set off. Okay, the last question was Norma's Salon Incorporated was buried in debts. Unlike 5 years ago, the salon was now facing tough competition from Bench Fix and Bruno's Barbers, to name a few. In an effort to reduce its ballooning debts, Norma's Salon delivered by way of Dashan and Pago 20 salon seats and 10 hair blowers to its principal creditor, China Bank. The items were collectively valued at 700,000 pesos. 7 months after, China Bank found that some of the salon seats and hair blowers were defective. China Bank sued Norma Salon Incorporated for breach of warranty against hidden defects. What is Dashan and Pago as a mode of extinguishing an obligation? In Dashan and Pago, the debtor delivers a determinate thing to the creditor as payment for the unpaid obligation. And we said that in Dashan and Pago, we applied the law on sales. Now, for the second question, in the case above, is China Bank correct in invoking the warranty against hidden defects? Explain. It is true that since the law on sales applies to a Dashan and Pago, thus warranty against hidden defects may also apply. However, remember that the warranty against hidden defects does not apply to second-hand articles. And in this case, the salon seats and hair blowers were second-hand articles. Thus, China Bank cannot insist on the warranty against hidden defects in order to rescind the contract or rescind the Dashan and Pago. Okay, so that's the answer. Alright, so let me check. Ilan na po tayo? 40. Okay, so hello everybody. Ayan, daming present. Okay. So Sandra, pasabihan yung mga nagtataka bakit walang tao sa Google Meet ha, na andito tayo lahat ngayon sa YouTube. Yung mga sino kaya nanonood na hindi ko estudyante, no? So if you're joining us this live stream and you're not part of the Civil Law Review 2 class of UE College of Law, welcome to my lecture on the law on contracts. Yan. Okay, so I hope you enjoy your stay here and I hope you will learn something, if not a lot, from this lecture. Okay, so let's now proceed. If you're ready, let's do this. So what is a contract? A contract is a meeting of the minds with respect to the other to give something or to render some service. Now, from this definition, we have the three important keywords: meeting of minds, parties, and obligation. If you have to define a contract, or if you will be asked to define a contract, make sure that you have all three keywords, okay, in the subject or in the definition. Okay, now note, however, that despite the phraseology which suggests that only one party has an obligation, a contract essentially involves reciprocal obligations. That's why the definition provided by the Civil Code has been criticized, because it appears that, or it implies that a contract only suggests that there's only one party, or that a contract is unilateral, but it is not unilateral. But nevertheless, the definition is correct, because in a contract, each party would be bound to perform his obligation. So each side would be an independent part of the contract. So as far as, let's say, one prestation is concerned, so you have a creditor-debtor. With respect to the other prestation naman, yung sa kabila, you also have the creditor or debtor. Now, to better understand this, we can just use or point to common contracts like a contract of sale, a contract of lease, a contract of loan. Okay, so a contract of sale, applying the general definition of a contract, it's a meeting of the minds. So there's an agreement, okay, in a contract of sale. Now, with respect to the other, so you have one party, so let's use the seller or the vendor, and with respect to the other, he promises to give something or to render some service. So what is this obligation? The obligation of the seller to the buyer is to transfer ownership and to deliver the thing. Okay, so tama naman yun. But then when we look at the other part of the contract, which is that prestation of the buyer, then we also have this different context. So with respect to the seller, the buyer has the obligation to pay the price. So yan, kaya reciprocal obligations. That's why a contract involves reciprocal obligations. Okay. Now there are, of course, unilateral agreements or unilateral transactions, like in the case of a donation. But donation is an altogether different concept, because here there is no obligation on the part of the donor to give something or to render some service to the donee. Neither is there an obligation on the part of the donee to give something or to render some service to the donor. A donation is based on gratuity or liberality on the part of the donor. So he gives it away, or the thing, or he gives away the thing out of his magnanimity or out of his altruism, and then the donee simply accepts that. And if you can call that an obligation, then that is the obligation to accept the donated thing or the thing subject of the donation. Okay, now let's look at the characteristics of contracts. Kita ba? Okay. See, the next slide shows the different characteristics of contracts. And these characteristics are relativity, obligatoriness, consensuality, mutuality, and autonomy. When presented with a question whether the contract is valid, it's not enough that you look at the elements or the requisites of the contract, or that you see if the three keywords are present. Kumbaga, yung meeting of the minds, the parties, as well as the obligation. But also, read the terms or understand the terms and conditions of the contract and see if these terms and conditions meet or comply with the different characteristics of a contract. So, parang kumbaga sa taxation, if tax is the lifeblood of the government, meron din tayong basic catch-all defense or catch-all argument for questions on or involving validity of contracts. So to know if the contract is valid, you must test that contract against these characteristics of contracts. So what are these characteristics? So let's start with relativity. So when we speak of relativity, we remember Article 13.11 of the Civil Code. So Article 13.11 of the Civil Code states that contracts produce effect as between the parties who execute them. In other words, contracts are binding only among or upon the parties who are privy to the contract. So a stranger has no business dealing or interfering or demanding benefits from the contract. Okay, because if you are not a party to the contract, then the contract does not bind you, neither do you have any right to demand anything from the parties to the contract. Now, this is borne by the doctrine of res inter alios acta, which states that a contract cannot adversely affect the rights of one who is not a party to the contract. But there are exceptions to the res inter alios acta rule. First is when the party executing the contract is an agent, in which case his principal is the real party in interest. So the other party to the contract can demand performance not or maybe from the agent as well as from the principal. Because I say maybe because that agent may also be authorized to perform the obligations of the principal in that contract. Okay, but at any rate, the agent is only an alter ego of the principal. So his principal is not a third party to the contract. He is not a stranger. Thus, he is not governed, or he is not affected by the res inter alios acta rule. Now, the next exception is that rights and obligations may be transmitted to heirs and assigns of the parties to the contract. So that's a general rule in civil law. All rights and obligations are generally transmissible. But there are exceptions to the transmissibility of rights and obligations. So what are these intransmissible contracts? So first, these are contracts which are purely personal. Okay, so what are examples of contracts that are purely personal? We have a contract of partnership and a contract of comodatum. These contracts are purely personal because the death of one of the parties to the contract extinguishes or terminates the contract or the relationship of the parties. There is no right of succession in a partnership nor in comodatum. So let me explain. In a partnership, if a partner dies, the partnership is dissolved because the heirs of the deceased partner cannot take his place in the said partnership. It is different in the case of a corporation because in a corporation, the death of a stockholder does not dissolve the corporation. The deceased stockholder can be replaced by his heirs. Or in fact, before he died, he could have executed, let's say, a transfer or a contingency such that in case of his death, his shares may be acquired by the corporation and the corporation will exercise the rights pertaining to those shares. That's possible in corporations. But in a partnership, the death of a partner dissolves the partnership and his interest in the partnership is not transferred or inherited by his heirs. Now, in the case of comodatum, remember that comodatum, or at least the obligations and the rights and obligations in a comodatum are based on trust and confidence. So a bailor will lend the thing to a bailee because he believes that the bailee can return the thing once the bailor demands the return of the thing. And this trust and confidence may be based on the personal characteristics of the bailee. Halimbawa, na mapagkakatiwalaan siya, he has a good background as far as diligence over personal properties or even real properties if real property is the subject of the comodatum. So, kung pinahiram niya dito sa isang tao na to, yung bagay na yon, it doesn't mean that the thing will also be taken care of by another person. So, kaya if the bailee or the borrower dies, then the contract is extinguished and the thing must be returned to the bailor. And the same thing is true if the bailor dies. So if the bailor dies, then the bailee has to return the thing to the heirs of the bailor. Okay, so basically that's it. No examples of intransmissible contracts. Now, another exception to the res inter alios acta rule is the stipulation por autrui. So what is stipulation por autrui? It is a stipulation in favor of a third person. This is an exception because, as we have said, the contract is only binding upon the parties to the contract. So bakit nagkakaroon ng situation where a third person may demand some interest or may demand some benefit in a contract to which he did not participate or to which he was not a party? Okay, so these are the requisites for a valid stipulation por autrui. So first, there must be a stipulation in favor of a third person. So the third person must be identified and the stipulation or the contract itself must state what kind of benefit or favor will be given to the said third person. Now, the second requisite is that the stipulation must be a part, okay, not the whole of the contract. So if the contract is entirely for the benefit of a third person, then it ceases to be a stipulation por autrui, but rather that becomes the main contract. Okay, so for example, in the case of a surety, in the case of a surety, so you have the principal debtor as the beneficiary of a surety contract, but the surety contract involves the creditor and the surety. So in that case, it ceases to be a stipulation pro autrui, but rather it's the main object of the surety agreement. So anyway, I will show you examples of a valid stipulation pro autrui. So the other requisites of a valid stipulation pro autrui are third is the contracting parties must have clearly and deliberately conferred a favor upon a third person, not a mere incidental benefit or interest. So the agreement itself, as I've said, must identify the third person, must specify what favor or benefit will be extended to that person. It is not a stipulation pro autrui if the said third person is merely, let's say, an heir or an assignee of a party to the contract, because technically speaking, he is not a third party but rather a representative or a successor to a direct party to the contract. Okay, so magiging incidental yun. Dapat talaga there is a deliberate conferment of some benefit in favor of a distinct third person. Okay, next, the favorable stipulation should not be conditioned or compensated by any kind of obligation whatsoever. So the third person doesn't have to assume any obligation. Now, next is that the third person must have communicated his acceptance before its revocation. It being a stipulation by the parties in favor of a third person, conditioned upon either the happening of an event or the existence of a right, it can also be revoked, before the happening of that event or the existence of that right. So the third person must accept that benefit before its revocation. Otherwise, if it has been revoked, then he ceases to have any interest in that stipulation. Now, lastly, neither of the contracting parties is a representative or agent of the third person. Again, because if he is only, or if this third person is the principal of a party to the main contract, then there is really no third person, but rather that third person is the real party in interest. Okay. So examples of stipulations pro autrui: sale of real property, but the buyer must first pay the vendor's loan, which is secured by a mortgage on the purchased property. So here, who is the third person? The third person here is the mortgagee or the creditor of the vendor. So in the contract between the vendor and the vendee, the vendor asks the vendee to pay off the unpaid loan on the property so that the mortgage on the property can be released. So the agreement is principally between the vendor and the vendee, but there's a stipulation there, which is the payoff or the settlement of the loan obligation, and that stipulation is in favor of a third person, which is the mortgagee. Yan. So kaya siya stipulation pro autrui. It is a stipulation in favor of a third person, and that this third person, once of course he accepts it, then of course it can demand the performance thereof from the vendee. Okay, the vendee is bound not only to the sale, but also the vendee or the buyer is also bound to pay off that unsettled or unpaid obligation. Now, another example of a stipulation pro autrui is casualty or liability insurance obtained by an employer for the benefit of his employees. So, the main contract is an insurance contract, particularly a liability insurance contract. So, it's a contract between the employer and the insurance company or the insurer. But the contract is in favor of a third person. Well, third persons to be exact, because the beneficiary of that contract are the employees of the employer. Now, of course, it's not automatic. The benefits will only be given to the employees if the liability arises. Kaya nga siya tawag liability insurance, because it insures against liability. So, I am supposing that this is liability because it's not employees compensation. So, hindi ito yung payment to employees in case of injury while in the performance of their official functions, because in that case that would be the main contract. But here, liability insurance means in case the employees commit let's say damage or injury to a third person, or if, let's say, while in the performance, or let's say a third person commits a negligent act or a malicious act against the employees, so the employees will be compensated out of the insurance policy which the employer took from the insurance company. Ayan. So, those are examples of a stipulation for autrui. Okay, before I discuss obligatoriness, tingnan ko sino nandito. Ayan, walang bago. Okay, hi, hello ulit sa inyo. Ayan. So we are 49 as of the moment, and thank you for staying. Ayan, tapusin natin to. Alright, so 29 minutes into this lecture, we are now on the topic of obligatoriness. So what is obligatoriness? The basis is Article 1159 of the Civil Code, and it states that obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. I mean, the Civil Code cannot emphasize it even more. It says that it's the law between the parties. So the violation of a contract is almost the same as a violation of the law. Kaya nga siya obligatory. Okay, next is consensuality. So the basis here is Article 1315 of the Civil Code, and it provides that the binding force of a contract is not limited to what is expressly stipulated, but extends to all consequences which are the natural effect of the contract, considering its true purpose, the stipulations it contains, and the object involved. Okay, we said that a meeting of the minds, or the consensuality, well, generally the parties consent to the object and the compensation or the consideration of the contract, like in the case of a contract of sale. So the parties must have a meeting of the minds over the thing and over the price. But okay, that's too simplistic to say that the parties did not also agree to other consequences of the contract. So parties to a contract of sale agree to many things as well, including, for example, the execution of a public instrument, because by usages and customs, as well as by express provision of the Civil Code, particularly Article 1358 of the Civil Code, contracts involving sale, transfer, or conveyance of real property or real interest in property must be in a public instrument. Okay, and later on I will talk about what right is given to a specific party by Article 1358 of the Civil Code, but it is there. Okay, so it is something that can be invoked by the parties to a contract of sale. Now, similarly, by usages and by related law, PD 1529 or the Presidential Decree or the Property Registration Decree requires that for the transfer of title from the seller to the buyer, what must be surrendered are the owner's duplicate as well as the proper deed of conveyance. So these are requirements that are not specified in the Civil Code or not included in the Civil Code, but are nevertheless demandable. So when parties enter to a contract of sale, they agree as well to these incidental stipulations or incidental obligations. So as a seller, although hindi sinasabi doon sa kontrata mo na ibigay mo yung owner's duplicate, you also agree, impliedly, you also agree to this requirement that you have to surrender the owner's duplicate of the certificate of title. Also, similarly, on the part of the buyer, if for example, hindi nakasulat doon sa contract or deed of sale nyo na mag-issue ka ng resibo, but by usages of trade, by usages of trade, the seller is or has the right to demand an official receipt. Okay, or sorry, not official receipt, but baliktarin ko pala, the seller pala has the obligation to issue an official receipt for purposes of paying off taxes. So, yung mga ganun, kasama na yun dun sa sinasang-ayunan ng mga parties. Okay, those consequential stipulations are included in what will be agreed upon by the parties. That's consensuality. Okay, next is mutuality, and the basis is Article 1308 of the Civil Code. So here, the fulfillment of a contract cannot depend exclusively upon the uncontrolled will of one of the contracting parties. In other words, a contract is for the benefit of both parties, and each party has the expectation that the other will perform his obligation according to what was agreed upon. So hindi po pwedeng discretionary sa part lang ng isang party to a contract yung efficacy ng kontrata. That's why we said in our earlier lecture, a potestative condition is void. Potestative conditions are those conditions the efficacy of which depend solely upon the discretion or the decision of one party. Okay, so a potestative condition violates the mutuality principle of a contract. Also, because of this mutuality principle, a contract cannot be unilaterally terminated without the consent of the other, unless such privilege is stipulated in the contract. But if it's not stipulated in the contract, one party cannot terminate the contract without the consent of the other. And we have discussed this about periods. So similar to the rule on periods, we said that a period is for the benefit of both the creditor and the debtor. So that's why if the debtor wants to pre-terminate the period, he has to get the consent of the creditor, because the creditor also has a benefit in that period. For example, in the case of a loan with interest, the longer the period is, so the more interest the creditor gets from that amortized payments. So that's it. Okay, now let's talk about autonomy. So the basis of autonomy is Article 1306 of the Civil Code. So here we said that the contracting parties may establish such stipulations, clauses, terms and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. Now, here's the beauty of contract drafting. In contract drafting, as a lawyer, you can draft or you can craft such terms and conditions which your clients or which the parties will find convenient. Now, normally, clients will come to you, or the parties to a specific contract will come to a lawyer or to a contract drafter and tell the lawyer or contract drafter that eto yung mga gusto naming mangyari. Okay? So, eto yung ini-expect ko sa kanya, siya naman, eto naman yung i-expect niya sa akin. So, you make it happen. Okay? So, usually the challenge there is for the lawyer to make it happen legally. In other words, you must have a grasp of kung ano yung bawal. You must have this, wide knowledge of law, of public policy, etc. Because while it is true that the parties are free to stipulate pursuant to their freedom to contract and autonomy, that freedom is subject to limitation, and that limitation is make sure that it's not contrary to law, morals, good customs, public order, and public policy. So, ano nga ba yung bawal? Diyan na papasok yung abogado. So, the lawyer should know when or what provisions cannot be agreed upon by the parties. Okay. Now, examples of contracts which were voided for being contrary to law or public policy. So, first, a contract of agency for following up papers in the different government offices to which they were referred. Okay, so this is an old case of fixing. Ayan. So we call this present ng mga fixers. Ayan. So fixing is a void contract. Why is it a void contract? Because number one, it presupposes that the person asking you to fix the contract is disqualified to avail of this grant from the government. Also, secondly, it is also against public policy, which is that government processes should not be the subject of corruption, or shortcuts. So this contract was seen as a form of corruption. So that's why it was considered void. Now, the other example of a contract which was voided for being contrary to law or public policy was a non-involvement clause, or that which indefinitely prohibits an employee from engaging in any business similar to that of his employee after the termination of his employment contract. What is void here is not the non-involvement or non-compete clause. What was declared void here was the indefinite prohibition, because in effect, by saying na hindi po pwedeng magtrabaho sa isang competitor company yung nag-resign na empleyado, that stipulation now impairs the right to labor or the right to seek employment of that resigned employee. Okay, but the Supreme Court said here that non-compete clauses are valid because they make sure that the trade secrets are protected and that the resigned employee will not support a competitor and give undue favor to a competitor. But then, that restriction should not be indefinite. So, in that case, the Supreme Court said that an acceptable or permissible prohibition would be from siguro at most 2 years. Yan, if I remember it right. But the Supreme Court said did not say na there is a law that says hanggang 2 years lang. But based on reasonableness of the prohibition, a prohibition of 2 years would be valid. But more than that, that would be too harsh and an unfair or an unlawful restriction on the right to labor. Okay, so those are, ay meron pa pala. Alright, another example of a contract that was rendered void is a compromise agreement for the settlement of an obligation arising out of a void contract. Okay, so here the contract that was deemed void was the compromise agreement. You see, here the Supreme Court applied the rule that the accessory follows the principal. So the compromise agreement arose from a void contract. So the compromise agreement sought to enforce a right or an obligation arising from a void contract. So here the Supreme Court said that compromise agreement cannot be sustained because it works like a cure to a void contract. And since this compromise agreement arises out of a void contract, then we follow the rule that the spring cannot rise above the source. Okay, another example of a contract that was rendered void is any stipulation where the fixing of interest rate is the sole prerogative of the creditor or mortgagee. So what was rendered void here was not the fixing of interest, but rather the unilateral fixing of interest. Meaning to say, fixing the interest or the right is given solely to the creditor. Now, remember our law on loans, it provides that interest to be imposed must have been agreed upon in writing. So in other words, both parties must agree to the stipulation on interest. If there is no agreement in writing, then the interest cannot be imposed. Now, similarly, repricing or adjustment of interest must also be agreed upon by the parties. Okay? Now, in this case, the Supreme Court, however, said that what is prohibited is without, or is that act of not giving the debtor an opportunity to accept or to reject the adjusted interest rate. Okay? Yung unilateral imposition of the interest rate is what is considered void. But in this case, sabi ng Supreme Court, yung PNB naman, may ginawa naman siya na PNB did something or gave the debtor something which makes the imposition of the new rates no longer unilateral. So ano yung ginawa ng PNB dito? Before repricing the interest rate, the bank served a notice to the debtor informing the debtor that effective a certain date, the interest rates would be adjusted, and this interest rate, and that the debtor is given a period to agree or to reject. If the debtor rejects the new interest rate, then he can choose to pay off the unpaid obligation or to assign or transfer the unpaid obligation to a new creditor, and that new creditor will pay off the PNB or the existing creditor. So meron siyang way out kung ayaw niya doon sa interest rate. Now also, sabi din doon, if we do not hear from you after a certain date, then we will suppose that you agree to the repriced or the adjusted interest rate. So in effect, sabi ng Supreme Court, ang bawal ay yung sole prerogative. Pero if the bank or if the creditor reasonably informs the debtor about the adjusted rates, then it is no longer a sole prerogative of the creditor, because the debtor is now free to accept or to reject the new rates. Ayan. So anyway, basahin nyo, maganda yung case na yan. Lalo na't applicable to kasi maraming nagugulat na, ano ba yan, last year nasa 6% lang utang ko, tapos ngayon 6.5 na. Ayan. Now, even Pag-ibig, understand, no, nagre-reprice din sila regularly. Pero I think there was a time na may offer sila na fixed or uniform interest rate for let's say 5 years. Now, clearly that is a marketing ploy of these financial institutions to attract debtors. On the other hand, yung iba naman na nagsasabi na we reprice every year and that is beneficial to you because posible siyang bumaba, posible di siyang tumaas. So it really depends upon market forces, as they say. So nasa debtor na talaga yon, yung kung alin ang pipiliin niya. Is it the fixed rate or is it the repriced rate, which usually is adjusted every year? Okay, basta importante, sabi ng Supreme Court, i-inform yung debtor before the repricing. Okay, last is a loan obtained by the municipality for the purpose of funding the conversion of the public plaza, which is a property of public dominion, into a commercial center. Sabi ng Supreme Court, this is a void contract because the object is not within the commerce of man. In other words, it is outside the commerce of man. And like other lands of the public domain or public dominion, a public plaza cannot be the subject of a private contract. Ayan. Okay. Alright, what are the elements of a contract? Okay, wow, salamat talaga sir. Pagpalain pa kayo ng Panginoon. Salamat po Andre Portelo. Thank you for watching. Ayan, keep on watching. Ayan. Sige, tuloy na natin. So, elements of a contract. 45 minutes na, nasa elements pa pala tayo. Naka 18 slides pa lang ako. Alright, so what are the elements of a contract? So the elements of a contract are consent, object, and cause. Now, before I discuss these elements, we have the types of contract according to perfection. Ito muna unahin natin ha. So, real contract is a contract that is perfected upon the delivery of the thing which is the subject matter of the contract. What are real contracts? Examples of real contracts are comodatum, mutuum, deposit. Well, of course, yung mga accessory, mga securities, contracts of securities like pledge, mortgage, ganyan. Pero, syempre, huwag na natin pag-usapan yun dahil nga sa PPSA na yan, sa Personal Property Securities Act. So, ibang araw na yun, ibang video na yun. But, basically, contracts under your credit transactions are real contracts because the contract or the contract is perfected upon the delivery of the thing. So if the thing that is not delivered, so in the case of a comodatum, if the thing borrowed is not delivered to the borrower, in the case of a mutuum, if the funds are not released or received by the debtor, and let's say in a contract of deposit, if the thing meant to be for safekeeping is not received by the depositary, then there is no contract. So they cannot demand from each other the prestations or the expectations in that contract unless and until the thing is delivered. Okay, next would be consensual contracts. And consensual contracts are contracts which are perfected upon the meeting of the minds. So the bulk or most of the special contracts are consensual contracts. So they are perfected by the mere agreement of the parties over the object and over the consideration. Examples are contract of sale, contract of lease, contract of partnership, contract of agency. Yan, consensual yung mga contracts na yan. So for example, in a contract of lease, the contract, okay, is perfected even before the property is delivered or the leased premises is delivered. So for example, there's a new mall opening in the neighborhood, tapos you decided to lease a space there, a commercial space, and so you are a lessee of that commercial space. Now, what if that building or that mall is still being constructed, and the delivery or the turnover is, let's say, 6 months after the execution of the contract? Are you required as a lessee to pay the rent for the 6 months before the space or the commercial unit is delivered to you? Well, the answer is yes, because generally the obligations of the parties arise from the perfection of the contract, and the contract of lease is perfected upon agreement. So the lessee should start paying the rent, because on the part of the lessor naman, the lessor will no longer offer the leased premises to a different person. So the obligation of the lessee is to pay rent, and in exchange to that, the lessor has the obligation to guarantee or to assure the lessee the peaceful enjoyment of the thing. At ibig sabihin nun, hindi na niya i-offer sa iba. But because this is a special case where the property being leased is yet to be constructed, then the parties can agree na magsisimula yung rent only upon delivery of the property. Okay, so depende sa kanila yon. Again, freedom to contract, autonomy of the parties. They can agree on such stipulations that are convenient to them. Okay, so the last type of contract is solemn contracts. What are solemn contracts? Solemn contracts are contracts which are perfected upon the execution of the proper form. So, are there contracts which require the execution of a proper form bago ito masasabing valid and binding? Yes, there are contracts which require a specific form. We will discuss more about forms of contracts after a few slides. No? But as an example of solemn contracts, you have a contract of agency to sell real property, contracts or donations of real property, a partnership where real property is contributed. Yan. So these are the contracts or examples of contracts which require the execution of a specific form before that contract becomes valid and binding. Yan. So let's now talk about consent. So what is consent? Well, consent is not just meeting of the minds. No, it is not as simple as the party saying yes to one another. Okay, if only it were that simple. Pero just like any other things that people agree to, like marriage or other relationships, may mga requisites yan. So first would be the capacity of the parties. The parties to a contract must have the capacity to give consent. So with respect to natural persons, the natural person must at least be of majority age, and the majority age is 18. If you were able to watch my recent video on law on persons, personality, use of surnames, and absence, then you will know that by virtue of the Family Code and Republic Act 6809, our majority age is now 18 compared to before na at 21 years old. So ngayon, a natural person is deemed capacitated to enter into a contract and give his consent when he reaches the age of 18. But this is not to say na that capacity is permanent, because that capacity can also be restricted or modified. For example, because of insanity, civil interdiction, etc. But what is important is that at the time of the execution of the contract, the parties must have the capacity, and in this case, the natural person must have the capacity. So you must be at least 18 years of age and with full capacity to dispose of his properties. Ayan, ibig sabihin walang civil interdiction. Now, with respect to juridical persons, the juridical person must be duly constituted in accordance with law. So again, na-discuss na natin to dun sa video ko on law on persons. A juridical person is constituted according to the requirements laid down by law. So for example, a corporation must be duly incorporated. But it's not the filing of the articles of incorporation that grants or that vests the corporation juridical personality, but it is the issuance by the Securities and Exchange Commission of a certificate of incorporation. Now, with respect to a partnership acquires legal personality upon execution of the agreement. So it could be a verbal agreement, or it could if halimbawa mayroong personal kung may real property yan, dapat in writing yun. So if there is an articles of partnership, then the execution or the date of the execution of the articles of partnership will be the date of the commencement of the legal personality of the partnership. So yun, kailangan nandun yun dun sa situation when the issue is about the consent. Now, the next thing to consider about consent is that the proper party or person must give consent. Okay? Walang problema pag natural person yan because siya lang naman talaga yun, di ba? But when it comes to or with respect to juridical persons, a juridical person can only act through its authorized representatives. So if it's a corporation, it's the board of directors or board of trustees that has the corporate powers to bind the corporation. So the contract must be executed, or the consent to the contract must be given by the person authorized by the board. Okay. Now, with respect to public corporations, under the local government code, it's the chief executive who has the power to give consent. Although the authority to give consent must come from the sanggunian. So all these must be taken into consideration to know if the proper party, if the party signing the contract is in fact the proper party, and he is in fact authorized to give the consent for let's say his organization or his principal. Okay, now take note of Article 1317. Article 1317 of the Civil Code states, a contract entered into in the name of another by one who has no authority or legal representation or who has acted beyond his power shall be unenforceable unless it is ratified. Okay, so that's why, kung maiisipin nyo, bakit familiar? Because we have a counterpart provision under Article 1403 number 1. Ayan, 1403 number 1 on unenforceable contracts. Ayan, so we'll talk about unenforceable contracts also in this lecture, pero mga towards the end na. Okay, under defective contracts. Okay, so let's now talk about offer and acceptance. Okay, in consent, kaya sasabi meeting of the minds, actually hindi naman talaga utak ang nagmi-meet doon, no? Rather, it's the concurrence of offer and acceptance. That's what we call meeting of the minds, because there is a concurrence of offer and acceptance. Now, first, the offer must be definite, complete, and intentional. Okay, so it cannot be an uncertain or a provisional offer. The offeror must be specific as to what he is offering, so that we can also demand from the offeree that his acceptance must be unequivocal, unconditional, and must not qualify the terms of the offer. So, an offeree cannot be expected to accept a provisional or an uncertain offer. So, yung offer pa lang dapat determinate na so that the offeree can accept it as it is. Okay? But, it is only when the offeror has notice of the acceptance will the contract arise. So the contract will not arise if the offeror was not aware of the acceptance of the offeree. Now, it is one thing if the parties are face to face, and it is another when the parties are in two different places and are merely communicating by correspondence or any other means of communication. Doon sa una, which is pag face-to-face, silence means yes. Okay? Pwede na when the offeree did not reject the offer, and despite having been given time to make his counter offer, he does not make a counter offer, his silence will be deemed acceptance. For after all, they are face-to-face. So yung offerer, mapapansin na niya yung behavior ng offeree. On the other hand, pag hindi sila face-to-face, silence cannot be taken as an acceptance because the offerer must have notice or knowledge of the acceptance before the contract arises or before the contract is perfected. It is important that the offerer is aware or has notice of the acceptance, because if he is not aware of the acceptance, he can withdraw it. Thus, the last thing to note is that the offerer may withdraw the offer at any time before acceptance. Ayan. Hello po, kamusta na po kayo dyan? Ako'y inom muna ng tubig. Ayan, okay. I hope okay lang kayo dyan, ha? Okay. Alright, let's now talk about vices of consent. So what are these vices of consent? Also called the defects of consent. Ayan. I-memorize nyo to, itong 5 to. Mistake, violence, intimidation, undue influence, and fraud. Ayan. Ngayon, syempre pwede yun may alternate yan. Pero, ang magkakasama dyan, itong violence, intimidation, and undue influence. At saka yung mistake and fraud. Okay. Towards our discussion, mapapasin nyo kung bakit. Okay, sige. Especially because when we talk about voidable contracts, may prescriptive period doon. So, yung prescriptive period na yon will be counted upon the accrual of the cause of action. So, kaya magkakasama dyan yung violence, intimidation, and undue influence. Samantala, yung mistake at saka fraud, magkasama din. Bakit? Can you guess by now? Well, because the prescriptive period is counted either from the cessation of the violence, intimidation, or undue influence, or the discovery of the mistake or fraud. O, kaya magkakasama yan. Kailangan pagsamahin niya yung tatlo. So, let's now look at these vices of consent. So, on mistake or error. So, the mistake or error must refer to the substance of the object of the contract. That is, the nature and conditions of the contract. It must not refer to some expectation, not principally related to the contract. Like, for example, bumili ka ng property sa Tanay, okay, Tanay Rizal, thinking that you can use it as a mountain resort tourism business. Okay. But then turns out hindi pumatok yung yung intention mong business na maging resort, maging tourism spot yung property mo. Okay. Now, that mistake or error has nothing to do with your contract. It may be your motivation, but motivation is different from the cause of the contract. Your cause there is to acquire the property. Your motivation is different. That's purely personal and it is not contractual. But if the mistake is with respect to the thing itself, like you thought you were buying a property with an area of 1,000 square meters, but what you got was only, let's say, 900 square meters. So that is a mistake or error that is substantial. So, that's a vitiation. That can be a ground for the vitiation of consent. But yung motivation mo and then unrealize yung motivation mo, that is not a mistake or error that can annul the contract, because it does not go into the substance of the object of the contract. Now, also, mistake or error can refer to the qualifications of the other party if such qualification is the principal cause of the contract. Now, this would apply to contract for personal services. So, for example, you are a new condominium owner or condominium property owner, and then you were looking for an interior designer. So, you found this interior designer, and this interior designer misrepresented that he or she is a licensed interior designer, and so you acted based on that misrepresentation, but turns out he or she doesn't have that qualification. Now, not only is it mistake or error, it is also fraud, because there was an overt or an active act on the part of the other party to misrepresent himself as a licensed interior designer when in fact he is not. But sa part mo naman, mistake and error ang nangyari with respect to the personal qualifications of the other party. And in that case, that is a mistake or error that can be considered as a vice of consent and can be a ground to annul the contract. Ayan. Ngayon pala, I have to be very careful do sa term, because pag sinabi kong annul at saka nullify, magkaiba yun. Pag sinabi mong annul the contract, that contract is voidable. Pag sinabi mong nullify the contract is void. So pag binaliktad mo yan, magkakamali tayo doon. So again, that is something we have to live with, especially with civil law, no? Because the remedies are different according to the nature or according to what kind of defective contract it is. Alright, now finally on mistake or error, the test of the error is its influence upon the party. So if the party would not have entered into the contract had he known the true fact, then that error invalidates the contract. So yun lang yung test. So halimbawa, yun na nga, yung property, kung nalaman mo na itong property na to ay less than 1,000 square meters, bibilhin mo ba? So pag sinabi niya hindi ko bibilhin niya kasi ang gusto ko, ang bibilhin ko talaga is 1,000 square meters. So there is an error. So pangalawa, halimbawa, kung nalaman mo noon pa na hindi pala malalaki ang alon sa Zambales at ikaw ay isang frustrated surfer, gusto mo maging surfer, maging world class surfers, bumili ka ng property sa Liuliwa kaysa San Felipe, Zambales. Alam na bakit yung nabanggit ko, because I miss surfing. Okay, these were so many years ago pa. Anyway, at any rate, pati kami rin medyo na-scam kami doon na. We thought the waves there are high enough during the monsoon season, si habagat, but it turns out hindi siya ganun ka-surfable. Talagang wasak or basag, I think the term is basag yung mga waves doon. So kaya sabi namin, between Zambales and Baler would be a better surf spot. But at any rate, let's say someone bought a property in Zambales wanting to become a great surfer by surfing the waves of Liuliwa, Zambales. Tapos turns out yun, kung nalaman niya wala palang waves doon na ganun kaganda, would he still buy the property? Ayan. So depende, pag sinabi niya na oo, okay, I will still buy it because what I'm buying is the property itself. Pero pag sinabi naman hindi ko bibilhin yan, now then that motivation goes into the essence or the substance of the contract. And if there was misrepresentation on the part of the seller, then that can be a ground to annul the contract. But if there was no misrepresentation and the buyer could have easily verified or checked the surf in Liuliwa, Zambales, then he could not use that as mistake or error or fraud committed by the other party kasi wala namang sinabi yung kabilang party. Anyway, so yan. So again, it's a case-to-case basis, and the court will have to be the authority on this question, no? Because as a rule, or the general rule is that once a contracting party signs or executes the contract, then he is bound by it. All these vices of consent are more of the exceptions rather than the general rule. So the burden is on the party using these as grounds to annul the contract to prove that they in fact comply with the requisites for these vices. Okay, now let's talk about violence. So what is violence? So on your screen you will find there the bold letters or the words in bold letters. So serious or irresistible force. So violence cannot be psychological violence, no? Rather, it should be physical violence. So there must be serious or irresistible force employed to obtain consent. Like, sinakal ka para pirmahan yung kontrata. Yan. So the requisites are, the physical force employed must be irresistible or of such a degree that the victim has no other recourse under the circumstances but to submit. and the force is the determining cause in giving the consent to the contract. Now, also note that there is violence that vitiates the consent even if it is exerted by a third person. Now, the law does not distinguish whether the third person is acting upon the direction of the other party or that the third person is acting independently. Okay? And he must have at least an interest in the contract, but he doesn't have to be the agent of the other party. Okay? Basta, for as long as there is violence or a physical force that is irresistible in nature, then that is violence that vitiates consent. Okay. Now, intimidation is present when one of the contracting parties is compelled by a reasonable and well-grounded fear of an imminent and grave evil upon his person or property, or upon the person or property of his spouse, descendants, or ascendants, forcing him to give his consent. Ito naman hindi siya physical, but rather it's psychological. Okay? Psychological, why? Because it is the fear. Okay? The fear of an imminent and grave danger or evil that compels him, okay, to sign the contract. So the fear of pain or danger is not only against himself but also against his spouse, descendants, or ascendants. Okay, so this intimidation is like violence without the physical force. Okay, so what are the requisites? The intimidation must be the determining cause of the contract or must have caused the consent to be given, and the threatened act must be unjust or unlawful. Third, the threat must be real and serious, there being an evident disproportion between the evil and the resistance which all men can offer, leading to the choice of the contract as the lesser evil. So in other words, in intimidation, there are two evils. The greater evil is the threat to one's safety or security. Okay? But the lesser evil is to sign the contract. So of course, you don't want, let's say this contracting party doesn't want to suffer the greater evil. So kaya napilitan siya to take on the lesser evil, which is to sign the contract. Now, lastly, it produces a reasonable and well-grounded fear from the fact that the person from whom it comes has the necessary means or ability to inflict the threatened injury. Thus, if the intimidation is false or fake because the person allegedly making the threat is only bluffing, or that he doesn't have the capacity to achieve his evil design, then walang intimidation. Okay, but then if the person creating this intimidation really is in a position to achieve the threat, okay, made, then of course there is intimidation. Thus, ginawa niya yun, kaya siya pumirma. So, if all these requisites are present, then there is intimidation that vitiates the consent. But note this exception. There is no intimidation when the other party threatened only to sue and enforce his rights. Okay, so litigation, fear of litigation is not intimidation. So, for example, there is no intimidation when the compromise agreement is entered into to avoid litigation. And by compromise agreement, kasama dito yung mga settlement out of court, ha. Hindi lang yung compromise agreement that is approved by the court. So halimbawa, nauuso ngayon yung mga I have to make a distinction na. First, okay, may mga collectors, collecting agents na mga bangko at saka mga financial institutions who do it the right way. At meron din namang iba na who do it in the not so right way. Ibig ko sabihin yung nanghaharas. Mamaya na tayo sa mga nanghaharas. Okay, dito muna tayo sa diplomatic. Okay, doon sa diplomatic, they will send demand letters and then they will file actions like small claims. They will also file, let's say, a criminal case for estafa or BP22, and then also kung gumamit ka ng credit card, then yung act involving access devices, yun, may criminal aspect kasi yun eh. So when they file that, then they inform the debtor na we can actually settle this. If you agree, here is a restructured loan. You sign this, you are bound by this, and we will withdraw all the pending cases. So, if that debtor signs that, later on, hindi niya pwedeng sabihin na kaya naman lang ako pumayag at pumirma do sa kontratang yon, itong restructured loan is because I was intimidated to sign the restructured loan agreement because of the pending cases. So sabi ng Supreme Court, that is not intimidation, because when the creditor filed those cases, it was only enforcing its legal rights as a creditor. So the intimidation must be the threat of an act which is unjust or unlawful in the first place. So filing of an action or the threat to file legal action, that is not an unfair, unjust, or unlawful act. Okay, kasi meron iba, kaya lang naman ako pumirma kasi nga sabi pag hindi raw ako pumirma, papailan ako ng kaso at masi-sheriff daw ako. Well, sometimes it pays to do some research, or better yet, get yourself a lawyer to know your rights and obligations. Okay, pero doon naman tayo ngayon sa mga nakaharas. Yung mga nakaharas, of course, that is something else. Kasi when they harass, they really intimidate debtors to do something against their will, no? So, for example, pag hindi ka nagbayad, we will send letters to, or we will tell your bosses, your management, or we will publish your name and your face in newspapers, or we will inform the entire, say, finance industry about your debts. Ganyan. So there is now a threat of disreputation, meaning to say his reputation would be destroyed, and there would also be a threat of libel. So in that case, pwedeng ma-intimidate siya doon into signing the contract, because that would be unlawful. Okay? So para na siyang grave coercion na din kung tutuusin, no? When you threat something with a crime in order to collect a debt. Ayan. So intimidation yan. Okay, now let's talk about undue influence. So ang violence speaks of physical force, irresistible physical force. Intimidation speaks of a well-grounded fear of an imminent and grave danger. So from physical force to psychological fear, eto naman, moral ascendancy. Okay, so what is undue influence? It is present when a person takes improper advantage of his power over the will of another, depriving the latter of a reasonable freedom of choice. Okay, the position of the other party is such that the other party cannot refute or cannot oppose the other. Kumbaga, halimbawa, a parent and a child, or let's say a boss and an employee. Okay, so there is undue influence when the other party takes advantage of that position of power, okay, over the other. Now, whether there is undue influence, the following shall be considered. Now, these are the factors to be considered, because hindi naman kesyo ganun yung posisyon ng dalawa, automatic may undue influence na rin yun. May undue influence na agad. Okay, so first is that the family, spiritual, and other relations between the parties. Ayan, so that's one. And, ayan, so kailangan and, hindi siya or. So hindi siya alternative, kailangan magkasama tong dalawa. So there is a position of power, and the other party must be vulnerable or weak with respect to the other. So the fact that the person unduly influenced was suffering from mental weakness, ignorance, or financial distress. That's why he was in a weak position and he could not counter or oppose the influence being exerted upon him. So yun yung undue influence. Pero kung wala namang position of weakness, kahit nandun yung position, ayun, so there's no undue influence. Kasi nga, there is no undue influence when the person supposed to be influenced is really a strong person, di ba? So undue influence only speaks of a situation where there is, well, because undue influence really is a question of power, no? So one is powerful and the other is powerless. Yan. Okay, next. Wait lang. Anong bago dito? Oh, by the way, been listening here since 5:30 p.m. Oh, hi Mr. Oltado. Hindi ka talaga hindi mo talaga ako iniwan. Char. Ay, walang bibitaw, walang bibitaw. Sa mga bibitaw, okay lang. I-break. Hindi, pwede nyo naman kasi i-on lang yung audio nyo. Huwag nyo na lang papatayin kasi sayang to. Pero anyway, pag gusto nyo panoorin ulit, of course, hopefully, YouTube will not get this off my channel. Nandun lang naman siya. Panoorin nyo lang siya ulit. I will have to review, no? Kung meron akong something na dapat i-gawin dito to make sure that I get to have it posted on my channel, whether I have to review, download or something. So yeah, I have to check this again. Pero natutuwa ako dito sa live stream na ito because I'm actually looking at real time. Syempre may konting delay, no? May konting delay siya. Siguro like a few seconds, no, before I see my slides in the monitor. Pero it is still live nonetheless. So instead of recording it separately and then uploading it on my channel, pwedeng ganito na lang gawin natin, no? Sige. I will consider that sa future videos natin. Yung alam, walang editing dito, so walang music. Ayan. Okay. So let's now talk about fraud. Ayan. So what is fraud? Fraud is every kind of deception, whether in the form of insidious words or machinations, manipulations, concealments, or misrepresentations for the purpose of leading the other party into error and thus execute a particular act. So fraud is deception. Fraud is panloloko. Ayan. Now, if present, it can either annul the contract or make the obligor liable for damages. So why the alternative remedies? Because there are two types of fraud. You have dolo causante and dolo incidente. So dolo causante determines or is the essential cause of the contract. Dolo causante is fraud employed at the time of the perfection of the contract. In other words, it is a deception to cause the other party to agree to the contract. So in that case, the contract can be annulled. It is voidable. Okay? Yan yung sasabi natin vice of consent, fraud, because consent is determined at the time of the perfection of the contract. Now, dolo incidente on the other hand does not annul the contract because the fraud here is employed in the performance of the obligation. So there is now a valid and binding contract, but in the performance of his obligation, the debtor or even the creditor committed fraud. So it could be misrepresentation. Halimbawa, ang debtor, sabi ni debtor, I cannot pay you for this month, or I can't pay you this month. So bigyan mo ako ng 2 months grace period kasi meron ako mabibentang property. And I'm telling you, ang laki na makukuha kong pera doon, na income doon. So I'm going to pay you 3 months in advance. So bigyan mo ako ng grace period na 2 months. So babayaran ko yung 2 months na yun plus 3 months in advance. So that's a total of 5 months after 2 months from today. Ayan. So syempre si creditor, syempre napapaniwala siya. So that is fraud, but in the performance of the obligation, and that obligation is the payment. So in that case, the contract is not disturbed, the contract is still binding, but the aggrieved party, the creditor, can sue the debtor for damages aside from, of course, specific performance. So it will be an action. Well, of course, this is supposing na hindi nga niya natupad yung pangako niya na 5 months kasi nga 2 months arrears at saka 3 months advance. So pag hindi niya nagawa yon, then of course the creditor can sue for specific performance and then ask for payment of damages because of the dolo incidente. Ayan. Okay. But if it is fraud or causal fraud or dolo causante, the following requisites must be present. First, it must have been employed by one contracting party against the other. Second, it must have induced the other party to enter into the contract. Third, it must have been serious. And fourth, it must have resulted in damage or injury to the party seeking annulment. So damage or injury here should be pecuniary, no? So for example, he has lost money or property, okay, but the mere about agreement but without parting with money, not yet, tapos saka na-discover yung fraud, then of course there is no damage yet, no? So he can decide to whether proceed or not to proceed kasi nga na-discover na niya ngayon kung ano yung totoo. Okay, so with that new knowledge, the question now is, will he still proceed? Ayan, kasi if he still wants to proceed, then okay na-waive na ngayon yung fraud. Okay, alright. Next, acts not considered fraudulent. So we have the following provisions in the Civil Code, and they provide. Let's start with Article 1340. So Article 1340 states that the usual exaggerations in trade when the other party had an opportunity to know the facts are not in themselves fraudulent. Article 1341 also states that a mere expression of an opinion does not signify fraud unless made by an expert and the other party has relied on the former's special knowledge. Article 1342 also provides that misrepresentation by a third person does not vitiate consent unless such misrepresentation has created substantial mistake and the same is mutual. And Article 1343 states that misrepresentation made in good faith is not fraudulent but may constitute error. Okay, so at any rate, whether it's fraud or error, pwede pa rin yung ground to vitiate the consent, thus to annul the contract, no? Ewan ko bakit ba sinabi pa ng Civil Code na it is not fraudulent but may constitute an error. So, ganun din, may ground pa rin to annul the contract. But at any rate, sasabi lang ng Civil Code, hindi po fraudulent yung mga yan. Well, una-una, dun sa usual exaggerations in trade. As a buyer, you must be a responsible and an intelligent buyer. You must know the difference between fact and fiction. Okay, so for example, merong ino-offer sa yung sapatos at sabi ng nagbebenta ng sapatos, sobrang tibay niyan sir, matatapos na lang ang mundo, ayos pa rin yung sapatos na yan. It can outlive the world. Or siguro, well, wala naman siguro nagsasabi na ngayon, pero lagi kong narinig yung mabubulok na lang ang paa mo, hindi pa rin mabubulok yung sapatos na yan. Okay, so of course that's an exaggeration, di ba? So as a responsible and intelligent buyer, you should know the difference between fact and fiction. Now also with respect to expert opinion naman, you must know, as a buyer, you must know if you're talking to an expert and that his opinion has an effect on your decision to buy the property. So mostly yung mga marketing spills na yan, they are not fraudulent. Okay, because again, the law also imposes on a would-be buyer or a prospective contractor or a prospective contracting party to the contract to do his research, no? And not just listen to and accept as fact whatever is communicated to him. Alright, now let's talk about the object. Tapos na tayo sa consent, object naman tayo. So the following are the requisites of a valid object. So first, it must be within the commerce of man. So when is it within the commerce of man? It is within the commerce of man if it is susceptible of alienation, appropriation, and private ownership. So anong pumapasok sa isip nyo na mga outside the commerce of man? So if you remember your law on property, so yan yung mga res nullius, mga lands of the public domain, ayan, yung mga services, personal services that cannot be the subject of appropriation. Halimbawa, di ba? Sexual services, because that's prostitution. Okay, what else? Sale of body parts. Those are not within the commerce of man. Okay. Now, it must also be licit or not contrary to law, morals, good customs, public policy, or public order. Now, a thing may be within the commerce of man, but by legislative fiat or fiat, that cannot be traded with or traded in. So, for example, let's say a fish pond may be allowed or used to be allowed. So you buy a property and then convert it into a fish pond and then you sell it. So pwede. And then later on, let's say a local ordinance is passed na hindi na po pwede. Okay, because of the threat to the environment or the threat to the local flora and fauna, etc., etc. Ayan. So that becomes now illicit because it becomes contrary to law, morals, or public policy. So there must be a specific law that makes this contract, not, or this thing or this object, not subject to commerce. Okay. Now next is it must be possible. So things are possible when they are within the commerce of man. With respect to personal services, they are possible when they are within man's ordinary strength or power. Now, whether it is possible or not is determined at the time of the performance, okay, and not at the time of the execution of the contract. So even though, let's say, doon sa execution of the contract, ikaw, bodybuilder ka, kaya mo magbuhat ng hollow blocks, ganyan. Bodybuilder magbubuhat ng hollow blocks, I don't think may connection doon, no? Because some bodybuilders just take steroids. They are not necessarily strong. Okay, so anyway, comment ko lang yan. That doesn't have to mean it's a fact. Okay. Anyway, so yan, bodybuilder nga. Plus ang ano is magko-construct siya ng bahay. So like ang sabi niya, in the contract, he will finish the contract to build the house like within 1 month. Okay, but is that within his ordinary strength or power? Maybe at the time of the execution of the contract, the bodybuilder siya, kaya niyang gawin niya within 3 months. But then on the date of the execution, let's say they agreed that the contract will be executed after 6 months. Ayan. So on the date of the execution, it becomes impossible. So in that case, the contract now loses an object, or the object becomes void now because the object is impossible. And lastly, it must be determinate as to its kind. So when is the object determinate? Well, it is determinate when it is certain, definite, and described. Although it doesn't have to be specifically described, like hindi kailangan yung serial number, hindi kailangan yung weight, hindi kailangan yung number, yung specific number, no? But at least it must be identified and segregated from its class. Okay, so halimbawa, pag sinabi mong rice, okay, so it should be at least weighted. So weight or weighed, weighted or weighed. Anyway, kailangan natimbang siya. So kailangan sabihin mo sa kontrata, 1 sack of rice. Kaya pwede sabihin na I am trading in or I'd like to buy rice from you, because the object there is indeterminate. Okay, so next, about the cause. So the cause is the why of the contract, the reason for the parties to enter into the contract. So it's the para sa motivation, it's the consideration, cause or consideration. Actually, they're the same. So what are the requisites of a valid cause? So first, it must exist. It must not be in the future, but it must exist at the time of the execution of the contract. Okay, next, it must be true. Meaning to say, it must not be fake, or it must not be fictitious or simulated. And lastly, it must be licit. In other words, the purpose or the reason for entering into the contract is not to do some wrong, okay, or to commit some illegality. Now, contracts without a cause or with an unlawful cause are void. But take note that although the cause is not stated, it is presumed that it exists and is lawful. O, diba? How contradictory. Ayan. So, ganyan talaga civil code. Pero, ang ibig sabihin lang naman is that, this becomes a rule on evidence lang eh. So, when the argument is that this contract is void because it doesn't have a cause, well, the presumption is that although it is not stated, the cause exists and it is lawful. So the burden is now on the plaintiff to show that in fact there is no cause, because contracts without a cause or with unlawful cause are void. So hindi automatic na kung silent ang kontrata mo, it is void. Okay? And I think that is a better rule than for the defendant to show that there is a cause. So maganda na lang na magkaroon tayo ng presumption as to the existence of a valid cause, para at least he who has an interest to challenge the contract has the burden to prove that there was in fact no cause. Alright, form of contracts. Ayan, kamusta na kayo dyan? Tingnan natin ano meron dito, mga greetings. Present po, hindi po ako nakahabol sa meet kanina. Oo nga, Mr. Beltran. Ayan, pati rin to si Mr. Malyari, wala rin siya kanina. At saka si Miss Olvido din. Good evening, sir. Sige, i-check ko na lang attendance niyo later. Okay, doon po sa mga hindi po kasama do sa class sa UE College of Law Civil Law Review 2. Ayan, welcome po sa inyo. Karamihan po na dito na nanonood ay mga estudyante ko po. And because I believe that legal knowledge should be shared, I decided to do this YouTube live para at least kahit hindi ko may estudyante makapanood naman dito. Ayan, goods pa rin po, sir. Ayan, goods. Yes. Uhusan ako na boses na mamaos na ako. Okay, imagine it's already 1 hour 33 minutes. Okay. Okay, let's now talk about form of contracts. So contracts are valid in whatever form, whether verbal or in writing. So that's Article 1356. So when form is absolute and indispensable, meaning to say, what are those grounds or instances when the specific form should be complied with? Okay. Well, kung remedial law to or rules of court ito, tagang sigurado talaga tayo. There is no doubt that the form is as essential as the substance. Okay, you have to follow or comply with the legal form, otherwise the action can be dismissed. Okay, but in civil law, pagdating sa contracts, generally forms are just secondary. In fact, you can have different forms for the same contract because the basic rule in contract law is that it is not what the parties call it to be, but rather it is what the law treats it to be. So, kung sinabi ng mga parties na contract of sale ito with right of repurchase, but then since the property was given away not for the purpose of transferring ownership, but rather for the purpose of securing a debt or a loan, then the law says that is an equitable mortgage and not a sale. O, diba? So, useless yung pag-execute nyo ng form and call it this contract when in fact the law treats it differently. Okay, but, okay, let's say there is no doubt that this is a specific contract, but then the question is there a required form for the said contract? Well, in the following instances, the form is absolute and indispensable. So the form must be complied with. So first is when the form is essential for its validity. At napag-usapan natin kanina, but more on that here. Also, when the form is essential for its enforceability. Okay, now, kalma lang, baka iisip nyo ngayon, di ba pag enforceability, hindi naman mandatory yun? It's still mandatory, it's just that meron lang siyang exceptions. Pero pagdating sa discussion or sa point na the form is required for its validity, that's really mandatory. Mandatory because if it's not complied with, then the contract is void. Pero pagdating sa enforceability, yes, it is mandatory, but then there are exceptions. So kahit na hindi siya nag-comply sa required form for purposes of enforceability, but if the exceptions are present, then the contract is now enforceable. Okay, maya-maya na yan. Dito muna tayo sa contracts that require a particular form for validity. Number 1, negotiable instruments like promissory notes, checks, and other bills of exchange. So the negotiable instruments law provides for the contents and the things that must be found in the instrument. So if the things of the or if these items or entries are not found, then the negotiable instrument is void. Okay, also donations, I cannot stress this enough. Okay, donations require a specific form, at ang pinaka-importante doon yung acceptance talaga, no? So kaya may specific form. Now, loans with interest, ang required form dito is with respect to the interest. So, pero isama na natin yan. Kasi pag nilagay ko yung interest dyan, syempre hindi nyo mag-get yung interest na sabi ni sir. So, loans with interest. So, the loan can be valid even if it's verbal, but if it is subject to an interest, the interest must be agreed upon in writing. Okay? So, kung wala yung writing na yon, yung written form for that interest, then the interest cannot be imposed. So, sabihin natin may utang, tapos may interest na verbal. Okay? The creditor can just collect the principal loan but not the interest. Okay? Because imposition of interest without the written agreement with respect to that interest is a void imposition. Okay. Next is agency to sell real property. Okay. Now, Confuse kayo nito pagdating doon sa enforceability ha. Kasi sasabi dito sa Civil Code that an agency to sell real property is void if not in writing. Okay? Nasa law on agency. Pero naging inconsistent yung rule na yon dito sa Article 1317 at saka 1403, because ang sabi ng Article 1317 and 1403, if a person acted without the authority of the person who is principally liable, the contract is unenforceable, okay, unless it is ratified. So in an agency to sell real property, it is still an agency. It's just that a specific form is required. So but then sabi nga ng discussion natin na to, the form is required for its validity. Okay? Validity for the agency to sell between the principal and the agent. But sige, I will explain that later pagdating natin sa unenforceable contracts. Okay. Next is contracts that must be in a public instrument. So these are the contracts involving real rights over immovable property, sale of real property or any interest therein, cession, repudiation, or renunciation of hereditary rights or those of the conjugal partnership of gains or absolute community of property, and power to administer property or power that may prejudice a third person, and cession of actions or rights proceeding from an act appearing in a public document. So this must be stated, or this must be contained in a public instrument. Okay? But contracts that involve an amount exceeding 500 pesos, these contracts must be in writing, even a private one. Okay. So, ito na ngayon ang malaking question. Okay? Itong Article 1358 na to, is this a requirement for the validity of the contract or for unenforceability? Itong paliwanag dyan. The requirement as to form under Article 1358 Civil Code is not essential for the validity of the contract. It is also not for enforceability of the contract, because when we speak of enforceability, then see Article 14032 of the Civil Code, which is the statute of frauds. Okay? So clearly, this is only, Article 1358 is only for convenience of the parties, so that meron lang silang evidence of the contract, and that because there is a provision of law that states or that provides that they should be in a specific form, then one party may compel the other to execute the proper form of the contract. So, nabanggit natin kanina yung consensuality, di ba? So, execution of the contract or the proper form may also go into the agreement. Okay, so if the other party refuses to execute the deed of sale, the written deed, the public instrument, say the notarized deed of sale, then the other party can demand it, because that's part of the agreement. And why is it part of the agreement? Because the law goes into the agreement. So Article 1358 is that basis. Ayan, for convenience lang siya, hindi siya for validity, hindi rin siya for enforceability. But it is nonetheless demandable because we have a specific provision for it, and that is Article 1358. Balikan natin na, ipa-flash ko lang ulit ano yung mga kontrata na dapat in a public instrument at ano din yung mga kontrata na dapat in writing, even if it is a private written private writing. Okay, or a private document. Yan, private writing, private document. So yan, basta it exceeds 500 pesos, then it should be in writing. Pero pag pinagawa mo sa abogado, ang charge na abogado is 1,000 pesos at least, or 1,500. Papagawa mo pa ba sa abogado? Well, the law naman doesn't require that it should be in a legal document. It only says a private document. Ayan, so that's why it is enough that the contract is written in a piece of paper, a notebook, etc. Pwede na yun. Okay. Alright. Now, let's go to Reformation of Instruments. Kalahati na. Okay, the total slides 61. Okay, nasa 34 na tayo. At hi po sa mga 53 na viewers natin ngayon. Ayan. Actually, hindi lang lumalabas sa counter ko na may 3 zeros pa dito. So, that's 53,000 viewers. Ay, nag-52 na tuloy. Ayan, sorry po doon sa umalis if you're not happy. Ayan. But I'm doing my best here. So, ayan. Okay lang, papatawa lang tayo. My failed attempt at be comedic. Okay, anyway. So, Reformation of Instruments. So, what is Reformation of Instruments? It is the correction of an instrument to express the real intention of the parties. That's why it says reform, to correct. Okay? But we correct or we reform the instrument, not the contract. Because the contract is already binding between the parties. Okay? But reformation is proper when the following requisites are present. First, there must have been a meeting of the minds upon the contract, and the instrument or document evidencing the contract does not express the true agreement between the parties. And lastly, the failure of the instrument to express the agreement must be due to mistake, fraud, inequitable conduct, or accident. Ayan. So, these are the requisites before reformation of instruments can be had. Now, a bit of procedure, ano kayang action ifa-file mo? Specific performance? Rescission? Ano kaya? Ejectment? Of course, ginugulo ko lang kayo. Now, the action for reformation of instruments is the same remedy for declaratory relief. Ayan. So, hanapin nyo na lang sa rules of court ninyo. Yun ang ipa-file nyo if you want to reform an instrument. Also, the same din yung declaratory relief, removal of cloud, at saka ito, reformation of instruments. So, it should be filed before the regional trial court. Ayan. Okay, next. When reformation is not proper, okay, so we have 3 types of contracts which cannot be reformed. So first, simple donations inter vivos wherein no condition is imposed. Okay. Second, wills. And third, when the real agreement is void. The reason for the first two is that they are essentially gratuitous, and the court cannot interfere with the wishes of the grantor. Yeah. And for the third case, which is when the real agreement is void, the reason why reformation is not proper is because the court cannot correct a void contract. Okay, because reformation is only proper when the defect is in the expression of the intent of the parties, but not the absence or the nullity of the contract. No? It cannot correct or it cannot make valid a void contract. Alright, let's now talk about interpretation of contracts. So the general rule is that if the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulation shall control. Okay, so read the contract as it is. The contract is the contract. Okay. Now, also take note of the parole evidence rule, which states that where the parties have reduced their contract into writing, the contents of the writing constitutes the sole repository of the terms of the agreement between the parties. Thus, extraneous evidence cannot be admitted, like a text message or an oral declaration. Hindi pwede admit yun because the effect would be to modify what was already reduced into writing. If the parties intended it to be in writing, then it becomes the sole repository of the terms of the agreement between the parties. Okay, but then nobody's perfect. Even these contracts are not perfect. So in case of doubt, what are the rules of interpretation? So the first rule is the plain meaning rule. So it states that when the terms of the agreement are so clear and explicit that they do not justify an attempt to read into it any alleged intention of the parties, the terms are to be understood literally just as they appear on the face of the contract. Okay, so when you read a contract, huwag nyo masyadong pahirapan ang sarili nyo. You just read it as it is. Okay, do not try to give it a different meaning. Okay, whatever impression it gives you after reading the contract, that is the literal meaning. Apply it as it is. Okay. Now, in case of doubt, okay, in the words or in the phraseology of the contract, then we follow the second rule, which is the supremacy of intent of the parties. So where there is ambiguity in the writing, the true agreement and the intention of the parties must be pursued. And to give effect to this intention, reformation of instrument is proper. Okay, next, contract must be taken as a whole. Where there are several provisions or particulars, the construction that will give effect to all shall be adopted. We do not follow the separability of laws or bills, no? In laws and bills, if one provision is declared unconstitutional, then the rest of the provisions of the law shall remain undisturbed and shall be given effect. But in a contract, as much as possible, take one, take all. Okay? All or nothing yan. So lahat, the entire contract must be taken as a whole. Next, usages or customs. The usage or custom of the place shall be borne in mind in the interpretation of the ambiguities of a contract and shall fill the omission of stipulations which are ordinarily established. Now, this is very common in cases of compensation for personal service or even rents for houses or properties in different localities. So, the parties may omit the specific price or the specific amount, but it doesn't mean they did not agree on the consideration. It's just that they open they subject the fixing of the amount to usages and customs, or they open the possibility that these amounts can be modified according to usages or customs. Yan. Okay. Now, next is interpretation against the party who caused the obscurity. So the rule is that the obscurity or ambiguity shall be strictly construed against the party who draws up the contract, and this finds greatest application in contracts of adhesion. So a contract of adhesion is a contract that is ready-made or prepared by one party for the other party to accept or to reject. Now, contracts of adhesion are not necessarily void just because they are one-sided. Okay? Of course, they are one-sided because they are prepared by just one side. But if the other party has the opportunity to review it and he can still reject it, if he decides to accept it and proceed with the contract, that means he agrees to the terms and conditions of the contract. So, walang problema. Now, note that just because the contract is a contract of adhesion and was ready-made, it doesn't waive, okay? It doesn't waive the right of the debtor, okay, to remedies under the law. So, for example, pag merong vitiation of consent, that can still be raised, notwithstanding the fact that the contract is ready-made. So, halimbawa, may mga terms doon na hindi niya maintindihan, o may mga terms doon na ang belief niya is ganito, yung pala iba pala ibig sabihin. So, halimbawa, nakalagay doon na ano ba mga contracts of adhesion? Halimbawa, insurance contracts, diba? So, insurance contracts. Okay. Smoking, ayan, let's say smoking. So, ang question doon is how long have you been smoking, or how often, how long? O sige, well, pag sabi mong how long, I think there's only one interpretation for that, which means gaano ka nakatagal nag-yosi. Okay, so how about how often have you been smoking, or how often do you smoke? So, ang sagot niya, often, or not so often. Okay. So, or how frequent pala, how frequent. When the insurer wanted the insured to state there the number of sticks per day, you cannot blame the insured applicant or the applicant for that insurance policy to state there the adjective, which is pag sinabi niyang just right, or parang ganyan, or just so often, parang ganyan, or occasionally, mga ganyan. Because the question itself na how often or how frequent, okay, are you smoking, ambiguous siya. It doesn't suggest the answer. But if the question was clear enough, like how many sticks in a day do you smoke, then at least masasagot ng tama yun, no, insured. But here, in case that insured will be disqualified for maybe concealment or misrepresentation, Diba yung beneficiary niya hindi makakakuha ng proceeds of the insurance because allegedly there was concealment or misrepresentation in the application for the policy. Then if I were the judge, I will resolve it against the insurer. Why? Because the question itself is ambiguous. So if the question is ambiguous, and since this was prepared by the insurance company, then resolve that ambiguity against the insurance company. Ayan. So that's the rule on interpretation against the party who caused the obscurity. Kaya pagka ganun, if you are drafting the contract, pag later on ba na-hire kayo ng isang company to prepare, let's say, a code of discipline, or let's say mga ganyan, mga insurance contracts, try to be more specific rather than use general words. Like tulad yan, how frequent. Yes, it's okay, frequent is a general term, but you can be more specific by asking how many sticks of cigarette do you smoke in a day. Yan. Okay. Alright. Now, last rule on interpretation of contracts is least transmission of rights and greatest reciprocity of interests. So, when there is ambiguity and the contract is gratuitous, the least transmission of rights and interests shall prevail. But if the contract is onerous, the doubt shall be settled in favor of the greatest reciprocity of interests. Okay, ito hindi na natin masyado to pinapansin, no? Pero tinan nyo ha, why the distinction is very, very important. If the contract is gratuitous, you apply the rule on, or the rule of the presumption in favor of least transmission of rights. Okay? Gratuitous, so least transmission of rights. Pag onerous, greatest reciprocity of interest. So examples of gratuitous contracts are donations, comodatum, okay? Yan. Basta yung mga walang compensation, mga walang bayad, hindi nagbabayad, tapos the other party just is in the receiving end of the liberality of the other party. What else? Waivers, okay? Waivers, condonation, remission of debt, yan. So lahat yan gratuitous yan. So if there is a doubt whether, okay, the comodatum is a contract of lease, whether it's comodatum or contract of lease, resolve it in favor of comodatum. Okay, why? Because lease transmission of rights. Okay, so ibig sabihin, bakit lease transmission of rights? Because in comodatum, the right of the bailee or the borrower is subject to pre-termination. Bakit? When the bailor, because the comodatum may be a precarium. If you remember what a precarium is, in a precarium, the bailor can demand the return of the thing anytime. Okay, so at will. A precarium is a comodatum at will. So ibig sabihin, mas least transmission of rights in comodatum than lease, because in a contract of lease, the lessor, okay, subjects the property to the right of the lessee to possess it for a very specific and definite time. Hindi niya pwede i-demand ang return just about any time. Okay, so comodatum versus lease, aside from the fact na sa lease kasi merong compensation, pero sa comodatum kasi, if it's the basis is only gratuity, then lease transmission of rights, then choose comodatum. Okay, if there is a doubt whether the contract is donation or sale, again, you have a gratuitous contract. So, lease transmission of rights, okay, ang tanong, donation ba or sale? Dito ngayon parang naging malabo because both of them result in the transfer of property. So, it doesn't really matter whether it's donation or sale kasi nga, wala namang one is whether lease transmission or the other one is of greater transmission, right? Pare-parehas lang yan. But, okay, if halimbawa, ang doubt is between donation as well as comodatum, okay, piliin mo yung comodatum because between comodatum and donation, walang transfer of ownership dito sa comodatum. So, pinapahiram lang niya sa'yo pero hindi niya binibigay sa'yo yan. Yes, gratuitous yung paggamit mo pero it doesn't mean you become the owner. Diba? So, ganun yung pagka-gratuitous. Pagka-gratuitous, as much as possible, avoid transfer of ownership or avoid a burden avoid an unnecessary burden on the grantor. Okay, but if it is onerous naman, in other words, where both parties suffer a burden, then the presumption is in favor of the greatest reciprocity of interest. So, ito na tayo ngayon. Pag nagbanggaan ang donation at saka contract of sale, the contract of sale is preferred because in a contract of sale there is greatest reciprocity of interest. Why? Because in contract of sale, both parties now perform or impose a burden on one another or on themselves. Sa part ng seller, of course, there's a transfer of ownership and delivery of the property, but at least the other party also imposes upon himself the burden to pay the price. In a donation, wala. Okay, yung isa, syempre, he will transfer the property, but the donee doesn't pay anything, or he only accepts it. So if the conflict is between sale or donation and the contract is supposed to be onerous, then choose the contract that involves greatest reciprocity of interest. Okay, so anyway, yan. Okay, now let's talk about defective contracts. Yes. Ano tayo? This class is only good for 2 hours. 3 hours ba to? Yeah, we usually start at 5:30 and end at 8:30, so 3 hours. Okay, so 1 hour 59 minutes. Okay, not bad. I still have 20 slides. Okay, kalain nyo yun. Contracts. Okay, let's proceed. So what is wait lang, makatingin nga tayo sa mga comments dyan. Comments sayo po, di nakabo sa meet kanina. Oo nga, lagi ka na lang late, Mr. Rosario. Ayan, si Mr. Serrade is watching from Butuan. Lagi ka lang nasa Butuan. Ayan, hi from Naga City, Camarines Sur. Hello po, Miss Lerma Castillo. Ayan, hi Mr. Ramos, kamusta? Ayan, so I hope everyone is learning something today. Ayan, sige, papahingin ko muna. Hello muna ko. Ayan, okay, because I'm having fun with this with this live. Ito lang pala gawin natin kaysa mag-record ako. Pwede na mag-record, yun na nga, because syempre nakaka-edit tayo, ganyan. So we can also add music, pero siguro next time I'll try to play something, let's say relaxing music like spa music. Okay ba yung spa music? Or baka na makatulog kayo, or maybe sa mga lighting, mga kandila ng ganyan, parang spa music talaga, ganyan. Spa environment, no? Siyempre, well, we are here not so much about the aesthetics and the visuals, but rather we are here for what you are hearing, no, and seeing on the screen. So yan, so makinig na lang kayo muna. Ayan. Alright, let's proceed. So defective contracts. What are the 4 defective contracts? We have void and inexistent contracts, voidable contracts, receivable contracts, and unenforceable contracts. Ayan. So let's begin with unahin natin. Siyempre, kung ano yung kasunod sa slides. Siyempre, it's receivable contracts. So, what are receivable contracts? So, first, what is rescission? Rescission is the remedy for the restoration of things to their condition at the moment prior to celebration of the contract. That's why rescission is also called restitution. So, what are the requisites for receivable contracts? Okay, not rescission under Article 1191. Okay, bakit may rescission under Article 1191? Well, actually, yun talaga dapat yung una-una pumapasok sa utak nyo when you say rescission. Rescission under Article 1191. So this is more of a special class of contracts that are rescinded, okay, for a different cause. Pero pag sinabi mong rescission, it's a counterpart remedy for specific performance. So, rescission is inherent in reciprocal obligations, di ba? Yan nasabi na Article 1191. So, it follows that there is a binding contract but one party fails to perform his obligation. So, the remedy is either specific performance or rescission. So, that's the general understanding of rescission. But here we are looking at contracts that are rescissible for specific grounds or reasons. So what are the requisites for rescissible contracts? Number 1, the contract must be a rescissible one, such as those mentioned in Articles 1381 and 1382 of the Civil Code. Second, the party asking for rescission must have no other legal means to obtain reparation for the damages suffered by him. Actually, parehas lang to doon sa rescission under Article 1191. Rescission as a remedy is subsidiary. The principal remedy is still to allow the other party to perform his obligation, or to allow, in the case of receivable contracts, to allow the other party to either rectify or to amend the contract and proceed with the contract. Ayan, so yan. So meron lang po tayong kotse na sira ang fan belt na dumaan. Ayan, sa labas. Okay, alright, next, the person demanding rescission must be able to return whatever he may be obliged to restore if rescission is granted. So yan, remember Article 1169 on delay or default? So sabi ng Supreme Court, or sabi ng Civil Code, there is no delay or default when when the party demanding the performance of the obligation of the other party is himself not ready to perform his own obligation. So he cannot demand or call out the other party for his delay kasi siya nga mismo hindi siya ready to perform his own obligation. So there is delay in a given case only when one party is already ready or has in fact performed this obligation. Similarly, in rescission of contracts, the person demanding rescission must also be able to return what he has received. So kung hindi na niya maibabalik yung kanyang natanggap, then he cannot demand rescission from the other party. Ayan. So, well, basically, yung principle nating come to court with clean hands also goes into this. Ayan. Alright, next requisite is that the things which are the object of the contract must not have passed legally to the possession of a third person acting in good faith. The action for rescission must be brought within the prescriptive period of 4 years. Let me just state that itong 1, 2, 3, fourth requisite, itong sabing the things which are the object of the contract must not have passed to an innocent purchaser for value is in fact a defense to an action Pollyanna. Okay, so what is an action Pollyanna? Well, it's an action filed to rescind a contract that was entered into in fraud of a creditor. So the creditor can sue the debtor and the third person. Okay, in order to rescind that contract, return to the debtor what has been transferred to the third person so that that property will be placed within the reach of the creditor, okay, as payment for the unpaid obligation. But that applies only if the third person is not in good faith. So kung in bad faith siya, so equally guilty siya with the debtor, so kaya pwedeng i-rescind. But if that third person was an innocent purchaser for value or a buyer in good faith, then he can be that action Pollyanna cannot prosper. Okay, all right, so I mentioned earlier rescission under Article 1191. And now let's look at the difference between rescission under Article 1191 and receivable contracts under Article 1381. So first, Article 1191 applies to reciprocal obligations where one party fails to comply with his obligations under the contract. Now, substantial breach is required. So a simple breach like non-payment of just one installment is not a valid ground for rescission. It should be substantial. Now, what is substantial will have to depend on the main obligation and the total number of breach, if ever. So, kung utang is 1 million, ang hindi nabayaran is only 1,000, that's not a substantial breach. But let's say the balance is 800,000 pesos against a principal obligation of 1 million. So clearly, that's a very substantial breach because that's a balance of 80% of the main obligation. Alright, next, Article 1381 applies to contracts where there is lesion, economic disadvantage, and fraud committed against creditors. Lastly, Article 1191 can only be asserted by a party to the contract. Article 1381 can be asserted even by a third person, for example, action Pollyanna in a violation of a right of first refusal. Okay, so nabanggit ko na kanina yung action Pollyanna, no? Alright. Okay, now let's look at the Receivable Contracts under Article 1381 and 1382 of the Civil Code. First, those which are entered into by guardians whenever the wards whom they represent suffer lesion by more than 1/4 of the value of the things which are the object thereof. Okay? So, lesion is para kang nalugi. Okay? So it's being shortchanged, no? And the amount or the lesion should be 1/4 of the value of the things. So let's say the value of the thing is 100,000, then 1/4 of that or 25% of that would be 25,000. Okay, pero before ko magbigay ng example, diretso muna tayo dito sa second, itong those agreed upon in representation of absentees if the latter suffer the lesion stated in the preceding number. So only in 2 instances can you use lesion, okay? And you will notice that the real victim there is someone who is either absent or is not in a position to bargain. Okay, like for example, a minor. So let's say a minor purchased, okay, bumili siya ng, let's say, a book, okay, o si kahit ano, basta worth 100,000 para mas madali ang computation. Okay, let's say it's a toy worth 100,000 pesos. Now the value is 100,000 pesos, but it was sold to that child for 125,000 pesos. So there is an overprice by 25,000. And 25,000 against 100,000, that's 1/4 of the actual value. Okay? Now, consider naman a different situation. Let's say dun sa pangalawa, an absentee, if you watched my video on law on persons, personality, personality, okay, pasensya na, buti hindi nyo naamoy yung hininga ko. Okay, I haven't had my dinner yet, so okay lang yan. Kasi syempre, diba, food is life but work is lifer. Okay, so going back, so in my video on personality, use of surnames and absence, a person who has been absent by leaving the domicile and his whereabouts are unknown, a representative may be appointed if he has been absent for 2 years, and that representative has the power to administer the property. But the real party pa rin dun is yung absentee. The representative is just an extension or an alter ego of the absentee. So whatever he does or whatever he suffers, it will be for the account of the absentee. So kaya dito papasok yan, yung lesion na yan. So let's say the representative of that absentee had to sell a property because there is a need to, let's say, pay or to provide financial support to the children of this absentee. So he gets the approval, this representative or administrator gets the approval from the court, so the court approves the sale. Sabi, okay, go ahead, you can sell the property of the absentee. Now, nabenta niya yung property which is 100,000 pesos but only for 75,000 pesos. So meron namang underprice. Okay, yung isang situation kayo na overpriced, nalugi yung, sabi niya tama, nalugi yung bata because he had to pay more by at least 25% or 1/4 of the real value of the thing. And also this one, the absentee, through his representative, suffered a lesion of 1/4 by having to sell a property for less than its actual value. And the lesion is 25% or 1/4. So, yung mga situations na ganyan, pwedeng i-rescind yung kontrata na yan. Okay, because one, ang reason is that yung isa is not, yung minor is not in a position to bargain, to intelligently bargain, and the other one is that because he was absent. Okay, now next, those undertaken in front of creditors when the latter cannot in any other manner collect the claims due them. Action Puliana. Alright, next, those which refer to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. So let's say the property is under litigation and that property is sold, okay, by the defendant prior to the termination of the case. So that sale to a third person can be rescinded, okay, under Article 1381. Pero here's an interesting question. Is it required that a notice of lease pendants should have been annotated on the title of that property before the sale of that property can be rescinded under Article 1381? Kasi sabi dito, under litigation. So, should there be a notice of lease pendants? Okay, so that the third person will know that this is under litigation? The answer is no. Okay, why? Because this provision is or creates a right in favor of the creditor. Okay, the notice of lease pendants is a notice to the third person. So, that notice of lease pendants, if not made, will only affect a third person, but it doesn't change the fact that the parties to the case are aware that the thing is under litigation. So kahit na hindi humingi ng notice of lease pendants si plaintiff/creditor, hindi mawawala yung right niya to sue or to file an action Pollyanna. Okay, because both him as the creditor and the defendant are aware that this property is under litigation, and yet this defendant sells the property to a third person. Okay, so next, payments made in a state of insolvency for obligations to whose fulfillment the debtor could not be compelled at the time they were effected. Okay, so in your insolvency law, you will know that the properties of the insolvent person are under what we call conservatorship or receivership. Okay, well, depende na kung anong batas gagamitin nila, and also if it's a natural person or a juridical person. At saka kung juridical person yan, ano ba yan, bangko ba yan o ano, diba? So, pero parehas lang ang concept niyan. An insolvent debtor cannot sell his properties which are under or which have been submitted to the court, okay, without the approval of the court. Okay, so kapag ka binenta niya yan, okay, okay, pagka binenta niyan, of course there is an action to rescind the contract. Now also, payments made, okay, halimbawa may utang, okay, may utang si insolvent creditor, insolvent debtor sa ibang mga creditors. Hindi pwedeng bayaran yun without the approval of the court, because even his payments must be approved by the court, because every money, every property that an insolvent person has must be held in trust for the benefit of all the creditors. Walang dapat nauuna sa iba. And that is why there is a payment plan or a payment schedule, okay, that the court will approve, so that all the creditors can concur in the properties or whatever remains of the properties and assets, including funds of the debtor. Okay, so all other contracts declared by law to be subject to rescission. Ayan, so check nyo na lang yung ibang batas dyan. Alright, next, voidable contracts. Okay, hey. Ilang contracts na lang? 3 na lang. Watching from Butuan. June Serada. Okay, hi June. Ayan, biyahe ka lang ng biyahe. Ingat. Okay, next, voidable contracts. So what are voidable contracts? Voidable contracts, they are existent, valid and binding, although they can be annulled because of want of capacity or vitiated consent of one of the parties. Okay? So, notice that it speaks of capacity and consent, but never about object and cause. Okay, tandaan niya na pagka voidable contracts, consent lang at sa capacity ang pag-uusapan natin. Pagka void contracts naman, all three are open for business. In other words, capacity, object, and cause. Pero pagka voidable contracts lang, consent lang or capacity ang affected. Okay, the object and the cause should be valid. Okay, because kapag ka-invalid ng object at saka cause, ipasok mo na sa void contracts. Alright, so voidable contracts are valid until annulled or set aside, but they are subject or they can be confirmed or ratified. Now, speaking of ratification, ratification requires a prior knowledge that the contract is defective, and despite the defect, okay, in the contract, the person who has the right to seek the annulment of the contract accepts the benefit of the contract or proceeds to perform the contract. So that's why meron ng ratification. And ratification now waives the right to annul the contract. Hindi niya pwede sabihin, okay, ra-ratify ko ngayon, pero siguro pag nagbago isip ko, I will sue for annulment. Hindi pwede. Once ratification is made, the defect is cured. Alright, grounds. Article 1390 provides that the following are voidable contracts. 1. Those where one of the parties is incapable of giving consent to a contract. Okay? In one party is incapable of giving consent to the contract. Ibig sabihin, one party is a minor. Okay? Or an insane or imbecile, ganyan. So again, panoorin nyo lang yung lecture video ko on the law on persons para maintindihan nyo yung mga capacity at saka yung mga circumstances that affect the capacity of a person. So sabihin natin minor, gamitin natin example ng minor. Now, Arturo Tolentino states that minority should be a ground for absolute nullity of the contract. It cannot be relative incapacity. But then the code, the drafters or the code commission decided to put this under voidable contracts. Now, of course, dapat Duralex Sedlex, huwag na natin pag-usapan to, no? But let's try to understand why a contract entered into by a minor is just voidable and not void. Okay, the reason is simple. A minor may have the chance to ratify the contract. Why? Because he can attain majority. So in other words, if he entered into the contract at age of minority, but let's say 3 years later he becomes an adult and he acquires legal capacity, he can ratify that. And if he ratifies that, then the defect is cured. What is more is that if the sale is for the benefit of the minor, or sorry, if the contract, nasanay lang ako sa sale. Okay, so if the contract is for the benefit of the minor, such as when it is for the support, sustenance, education of that minor, then it is valid because that is for the best interest of the child. Okay, so why consider it void when it was in fact entered into for the benefit of the child? So here the ratification can be made by the parent or the guardian. So kaya the Code Commission was correct na isama to dito sa voidable contracts because there is a positive purpose or a positive reason for just putting it under voidable contracts, and that is it can be ratified or it should be held valid until it is annulled. Okay, so ayan, malinaw na yan ha. Ayan. Pero anyway, basahin nyo na lang yung kanyang kanyang argument. Pero kasi argument niya kasi is that based on the other codes like the Argentinian code, mahilig siya mag-cite ng mga codes ng ibang bansa. Ayan. So, well, of course, I'm not saying that they are irrelevant because our civil code, after all, follows this large world system of civil law. So, kaya dapat meron silang interrelation or consistency because we are a civil law country, so we pattern our laws from these civil law jurisdictions. Kaya tinitingnan niya bakit meron doon sa atin wala. Well, ultimately our legislators had decided to go against the grain and consider this circumstance merely as a ground for voidable contracts. Okay. Hindi naman tatanong sa bar yan, pero malay natin, di ba? Knowing Justice Lonen, di ba? Baka nga pina-explain pa sa inyo why, bakit civil code, bakit hindi Kodigo Sibil. Di ba? Okay, next. Those where the consent is vitiated by mistake, violence, okay, di ba? Okay, pikit tayo, memorize ulit natin. So what are these vices of consent? Mistake, violence, intimidation, undue influence, and fraud. Oh, di ba? Yan, tandaan talaga yan, limang yan. Okay, now, annulment of contract. Okay, by the way, tinan yung grounds. Dalawa lang talagang grounds for voidable contracts. And they go into the consent or capacity of the parties. Okay, so let's now talk the procedural aspect of the annulment of the contract. So first, it must be brought within 4 years. Okay, but when? Okay, so kaya ito sasabi ko, pagka mistake and fraud, the 4 years shall be counted from the time of the discovery of the fact that was concealed in case of fraud, or the true fact in case of mistake or error. Now, if the ground is violence, intimidation, or undue influence, then the 4-year period shall be counted from the cessation of the violence, undue influence, or intimidation. So yan. So kaya magkaiba kung kailan magsisimula yung 4-year prescriptive period. Next, because it's an equitable remedy, the party who can file the action to annul the contract is the victim. Hindi pwede yung offending party. So it may be brought only by the victim and not the party responsible for the defect. Now, this is very interesting. If the ground is incapacity, halimbawa, the minor files an action to annul the contract because of his incapacity, then of course the action will prosper kasi siya naman talaga yung victim. But what if, okay, that incapacitated person misrepresented himself as an adult and induced the other party to believe that he is an adult, and for which reason this adult entered into a contract with this incapacitated person. So in this case, the party, the incapacitated person, cannot take advantage of that to escape from the consequences of the contract which he sought out himself. Ibig sabihin, you cannot kumaga, yung saying natin na you cannot have your cake and eat it too. Ikaw na nga yung minor, nagpanggap ka na adult ka, bumili kang alak, kaya nakabili ka na alak, tapos hindi mo mabayaran ngayon, so i-annul mo ngayon yung contract because of your incapacity. But you look like you're an adult, kaya you act like an adult, and so the other party was induced to believe that you are in fact capacitated to enter into the contract. So in this case, you are the guilty party even though you are incapacitated. So you could use other grounds for annulling the contract, like mistake, violence, intimidation, undue influence, and fraud, but not your incapacity. Okay, so come to court with clean hands. Alright, now next, like rescission, the effect of annulment is mutual restitution. The exception is that when the principle against unjust enrichment applies. So you cannot demand the return of the thing if, for example, if the thing is to be returned, like for example, a contract of lease. Okay, so it's a contract of lease of property, and let's say the plaintiff or the victim was allowed to remain in the premises. Okay, and then he paid rent. Okay, so nagbayad siya ng rent. Ngayon, for some reason, let's say mistake or fraud, so the contract was annulled. Ngayon, restitution is required as a consequence of annulment, di ba? Now, will you require the lessor to return the lease or the rentals, considering that the lessee was already had been in possession of the property? Well, that will result in unjust enrichment kasi ang mangyari, the lessee would have stayed in the leased premises for free. Okay, so hindi na ibabalik sa kanya yung rent kasi nga, after all, na-occupy naman niya yung leased premises. Alright, okay, let's now talk about unenforceable contracts. Unenforceable contracts. An unenforceable contract is one which cannot be enforced or does not produce legal effect unless it is first ratified in the manner provided by law. Doon pa lang sa statement na yon, ang tanong mo agad, is it valid until unenforced? Diba? Kasi pag recessible contract, valid until rescinded. Voidable contract, valid until annulled. E paano pag unenforceable contract? Is it valid until unenforced? Well, unenforceable contracts are no contracts at all unless it is ratified. But it may have all the requisites. It may have all the elements. So, that's what makes it different from void contracts. Kasi pag void contracts, walang elements yun eh. Or may problema sa elements. Dito, the elements are present. There are no defects. It's just that it's not executed in accordance with the law, with the manner provided by the law. That's why it cannot be enforced. So, it is valid but cannot be enforced. Okay? Because pag sinabi mong void yan, hindi siya unenforceable, void contract siya. Okay? So, kung kailangan ng isang sentence, okay, it's an enforceable contract, it's a valid contract but cannot be enforced. Now, the term statute of frauds is descriptive of statutes which require certain classes of contracts to be in writing. If the contract is not in writing, it is unenforceable. Okay, more of the statute of frauds in a bit. So, let's now look at the unenforceable contracts under Article 1403. Okay, so again, balik tayo doon sa form of contracts ha. Ang mga laging tatandaan natin ay Article 1358, okay, 1403. Okay, at saka other special laws that require or special or specific provisions in the civil code that require a specific form for the validity of the contract. Okay, now we're talking about requirements for the enforcement of the contract. Okay, ulitin natin, forms or the form of the contract can be relevant only for three reasons. If it's for the validity, it's for the enforceability, or for the convenience of the parties. Okay. Now, let's look at unenforceable contracts under Article 1403. And these are those entered into in the name of another by one without or acting in excess of authority. So, for example, an agent acting for and on behalf of a principal. So, yan. It is unenforceable if that agent has no authority, or even if he had authority but this act was not within his authority, or even if he had authority over this transaction but he exceeded his authority. Like for example, he was told to collect cash but he collected payment by credit. Okay, so yun, that would be exceeding his authority. So the contract entered into by that agent is unenforceable against the principal. Next, where both parties are incapable of giving consent. Ayan. So, hindi ko na kailangan ulit-ulitin to ha. The reason is that even though both are incapable of consent, they are capable of ratifying the contract. Okay? So, for purposes of classification, pag iisa lang ang incapable, voidable. Because after all, it's valid upon or against the other party who is capable. But if both of them are incapable of giving consent, then it's unenforceable. There is a contract but it cannot be enforced because they are incapable of giving consent. So paano ngayon makukure at para ma-enforce yung contract pagka both are incapable? Di hintayin na magiging capable sila, in other words, when they reach majority age or through their parents or guardians. Ayan. So again, wag natin i-totally avoid ang contract entered into by a minor. Yan ang sabi ng Code Commission, hindi ako nagsabi niyan. Okay, next, those which do not comply with the statute of frauds. And this is where we find the more interesting stuff. At saka dito kayo makahanap ng maraming questions sa bar. Ano ba to statute of frauds? Ano ba yung mga kontrata na dapat in writing so that they can be enforced? Because as far as itong dalawang to under Article 1403, itong those entered into in the name of another by one without or acting in excess of authority, or those entered into by when the two parties are incapable of giving consent, wala namang requirement na there should be a contract in writing. Even if, let's say, the agent executes a written contract, it doesn't change the fact that he has exceeded his authority. Also, halimbawa, they are both incapable of giving consent. Even though they execute a written contract, that written contract is useless because the issue here is the fact that they are both incapable of giving consent. Okay, so yung written requirement na yan, dun lang yan sa statute of frauds. Ayan, okay. So, what are agreements that are covered by the statute of frauds and should be in writing? So, agreements, number one, agreements not to be performed within a year from the making thereof. In other words, they agree now but they defer execution of that contract to another year. Ayan. So, there should be an evidence of that agreement. Otherwise, if there is no agreement, when the time comes, it cannot be enforced. Okay, so that written agreement will become the basis for the enforcement of that contract a year later. Okay, next, special promise to answer for a debt, default, or miscarriage of another, such as a guarantee or a suretyship, so it should be in writing. Also, agreement in consideration of marriage other than mutual promise to marry. So, example, marriage settlement or a prenuptial agreement. Kasi pag antenuptial, after na yan, di ba? So, prenuptial agreement. Ayan. So, that should be in writing. Okay, next. Agreement for the sale of goods, etc. at a price not less than 500 pesos. O, diba naalala yung Article 1358, any contract involving an amount of money more than 500 pesos should also be in writing even if it's in a private document. O, consistent siya dito sa 1403 number 2 that it should also be in writing if the price is more than 500 pesos. Next, contracts of lease for a period longer than 1 year should also be in writing, but if it's less than 1 year, then a verbal agreement is valid. And enforceable. Okay, sorry. Enforceable lang tayo dito. Yung word na gagamitin natin dito, enforceable lang. Kasi nga valid na talaga siya. It's just that it's unenforceable. Next, agreements for the sale of real property or interest therein, okay, regardless of the price. Also, representation as to the credit of a third person. So similar, parang surety, ganyan. Okay, or security. Yes, any security or any accommodation should also be in writing. Now, if it's not in writing, it does not comply with the statute of frauds, thus it cannot be enforced. Okay? Ayan. Ganun ka-strict ang statute of frauds, it cannot be enforced. Kaya pumunta ka sa court, kung wala ka namang ebidensya in writing, then it's useless. Kaya notice that kahit ang small claims requires that it should be in, at least there should be evidence in writing. Pero just because wala ka ebidensya in writing, it doesn't mean na hindi mo na pwedeng ma-pursue ang small claims mo. Kasi if you look at the form there, may tinatanong pa doon, any other evidence that you have to prove the debt or the obligation. Ayan. So, paano mo mapuprove yun? Well, the Civil Code also suggests what other evidence can be presented in order to prove a contract that, or rather, to make the contract enforceable. Ito na. The statute of frauds requires that the contract be evidenced by some note, memorandum, or any writing. But, if, during the litigation, the parties to the action did not make any objection to the admissibility of oral evidence. For example, yung complainant or yung plaintiff nagte-testify about the loan, okay? Although it was not in writing, but he testified on the loan verbally. Okay, that it was a verbal agreement that I delivered to him the amount and then he paid to me, let's say a partial amount, but he never paid again. Ayan. So obviously the contract is merely verbal. If the defendant fails to object to that, then that failure to object is considered that oral contract now becomes binding as if there was a written agreement. Okay. Now, next is that when we say that the statute of frauds applies only to executory contracts. This means that if the contract has been partially or completely executed, then the statute of frauds does not apply. So, in both instances, the two exceptions operate as ratification of the contract. So, yun ang ibig ko sabihin kayo na even in small claims or any other case, kahit wala kang evidence in writing, but if it is ratified through, let's say, an admission, okay, like halimbawa, text message, sabi niya, ang sagot nung may utang sa'yo, pasensya ka na kasi medyo gipit lang ako ngayon, di ba, babayaran kita sa katapusan. Ayan, that's already an admission. Okay, next, what if the contract was already partially executed by, let's say, the delivery of the thing? Let's say it's a contract of sale, the property has been delivered to the buyer, and the buyer has in fact possessed and occupied the property. So, in that case, the contract has been partially executed on the part of the seller. So, wala na, hindi na madi-deny ni buyer yung kontrata. The kontrata has already crossed, okay, the line, so to speak, that requires that the contract be in writing. It has now left, okay, the world of the statute of fraud, so to speak. Alright, now let's finally, we will talk about void and inexistent contracts. Wait lang. Kamusta na kaya kayo dyan? Nandyan pa ba kayo? Yes, correct. Under the new rules, kailangan na po i-attach. Yes. So, kung wala ka namang ebidensya, wala kang i-attach, di ba? Edi ang strategy mo is ipatestify mo yung witness mo. And then, if the witness testifies on an oral contract, kasi nga ano na may i-attach mo sa complaint mo kung the contract is oral, di ba? Picture. Picture, nag-exchange kayong pera, ganyan. Pero anyway, pwede naman text messages, sulat, demand letter, lahat i-attach mo. But then kasi, ang tanong, will that be considered as ratification? Yes, maybe, pero kung hindi, pero kung i-object niya ng defendant, di baliwala yung demand letter mo at saka yung mga text messages mo. But the best way is to have your witness or the creditor testify. And if he testifies, his oral testimony, of course, testimony is oral, no? So oral testimony, if unrefuted, becomes evidence of the unwritten contract. Ayan. Okay, thanks Nadine. Okay, next. Nasaan na tayo? Void contracts. So, void contracts and inexistent contracts. Wait. So, what are the void or inexistent contracts? Specifically, what are the grounds? So, Article 1409 of the Civil Code provides that those whose cause, object, or purpose is contrary to law, morals, good customs, public order, or public policy. Also, those which are absolutely simulated or fictitious. Also, those whose cause or object did not exist at the time of the transaction. Those whose object is outside the commerce of man. Those where the intention of the parties relative to the principal object of the contract cannot be ascertained, and those expressly prohibited by or declared void by law. Okay, so clearly the contract is void because of a defect in the object or the cause. Okay, because if it's just consent, then it's either voidable or unenforceable. Okay, now as I said, kailangan meron lang kayong ready na knowledge, no? Hopefully your stock knowledge about kung anong bawal is wide enough. So when you are presented with a problem, dapat isipin nyo na baka merong batas na nagbabawal nito. Ayan. So isipin nyo lagi, halimbawa, okay, it appears that on its face it's okay or that it's valid, but then try to be the devil's advocate at isipin nyo, baka hindi pwede to. So alam mo yun, but then of course when taking the bar, you don't have the luxury of time na maging skeptic ka na para isipin mo, parang hindi pwede to ganun ka, tapos mauubos na oras mo kakaisip kung bakit hindi siya pwede. Okay, so yun. But okay, syempre meron na mga times na kita mo naman on its face, this is void, foreigner wanting to buy property in the Philippines. Property covered by CARP and then it's being sold within the prohibitive period. Okay, what else? Kidney or body organs being sold in the public market. Hindi rin pwede to. So yung mga ganong mga talagang they become like an enlightened fact, no? Or discoveries. Okay lang yun. Pero yung mga iba, isipin nyo, try nyo muna. Okay, look at the elements. Are the elements present? Look at the form. Has the form been met? Tapos finally, tingnan mo itong grounds for void and inexistent contracts. Kasi madalas ang tanong, basta contracts, is the contract valid or is the contract void? Can the contract be enforced, etc.? Okay, so yan yung mga list. So try to just familiarize yourself with that. Okay, now, some notes on void contracts. A void contract produces no legal effect, so there are no rights and obligations that can arise from a void contract. Next, it cannot be confirmed or ratified. Third, the action to declare the nullity of a contract and the right to set up the defense of nullity of a contract does not prescribe. So, imprescriptible yan. Notice that recessible and voidable contracts have a prescriptive period of 4 years, but void contract can be or an action to declare a contract void can be filed anytime. Okay? Because walang prescriptive period. Okay, third or fourth, if the contract has been performed, the restoration of what has been given is in order. In other words, meron ding restitution. But take note, where the parties are mutually guilty or are in pari delicto, they will not have any right of recovery. Now, exception to the exception is when the rule will violate a public policy. So in other words, if there is a public policy against, let's say, foreign ownership, then you cannot apply in pari delicto to keep the parties, let's say the Filipino and the foreigner, where they are. So there should be restitution just the same, because to allow the foreigner or to hold the foreigner in pari delicto and to keep him where he is, that will allow him to keep the property which in the first place he has no right to hold or to own. Ayan. Okay, now we have some exercises. Ayan. So, babasahin ko lang to. For my students in UE Law, please email me your answers. My email address is ajumrani2000@gmail.com. I'm sure you remember that siguro from our previous assignment or exercise where I also ask you to email me your answers. Pero yun na, para hindi na kayo mag-type dito. But of course you are also free to type your answers naman. But for me to be able to read them, and then of course para walang limitations dun sa space and all that, although I discourage you from writing your answers too long, no, but you can send me your answers to these questions to my email address ajumrani2000@gmail.com. Okay, all right, so let's look at the first problem. So Greeley, an Italian national, and Rebecca, a Filipina, were common law partners. Greeley gave money to Rebecca for her to buy a beach lot in Siargao Island and to register it in her name. Then they executed a contract of lease which stipulated, among others, that Greeley would rent the lot for a period of 50 years to be automatically renewed for another 50 years for a monthly rental of 10,000 pesos, and that Rebecca as the lessor was prohibited from selling, donating, or encumbering the said lot except with the written consent of Greeley. Also, they executed a memorandum of agreement whereby Rebecca acknowledged that the money used in buying the property belonged to Greeley and that should they separate, Rebecca must deliver the property to Greeley. Subsequently, they broke up and Greeley ordered Rebecca to vacate the property. Rebecca, however, claimed that the contract of lease and MOA are void and countercharged for ejectment. Okay, so simplihan natin to. So you have a foreigner, had a girlfriend in the Philippines. They decided to buy a property in Italy, in Siargao. But because the Italian cannot buy the property, he gave the money to Rebecca. Rebecca bought the property. The title was in the name of Rebecca. Now, for the foreigner to be able to make use of the property, Rebecca executed a contract of lease with Greeley so that Greeley can stay in the property. But the lease contract is good for 50 years, renewable for another 50 years. Okay? So that's a total of 100 years. Now, in addition, the lessor's right to sell, encumber, or alienate the property is impaired, meaning Rebecca cannot sell, alienate, or encumber the property without the consent of Greeley. And in addition to that lease contract, they also entered into a memorandum of agreement whereby Rebecca acknowledges that the money in purchasing the property belongs to Greeley and that they agreed, both of them, Rebecca and Greeley, that should they separate, Greeley has to return the money to, Rebecca has to return the money to Greeley. Ayan. No, not the money, but Rebecca has to deliver the property to Greeley. Ayan. So, ibig sabihin, hindi talaga lalabas, hindi talaga aalis si Greeley sa property. Okay, so the questions are the contract of lease and MOA valid? Why? Will the in pari delicto rule apply and the parties left where they are? Why? Okay. So yan po ang katanungan. That's the first set of questions, okay, for you with respect to the first question, first problem. Okay, so if you need to review, you can just watch back this video. Basta yan yung una nyong question. And there are two more. Okay, so the next question is this. Rochelle was selling her house and lot in Kawit, Cavite for 5 million pesos. She verbally appointed her friend Dessa as her agent, who then offered the property to Lynette, who accepted and paid 200,000 as partial payment out of the 5 million purchase price. When Lynette went to Rochelle to give the check for the balance of the purchase price, Rochelle refused and told Lynette that she is not bound because the contract was void and or unenforceable because since the contract of agency to sell was not in writing as required under Article 1403 and Article 1874 of the Civil Code. Okay. So ulitin natin na Rochelle has property. She appointed verbally, okay, her friend Dessa to sell that property. Now Dessa was able to convince Lynette to buy the property. Lynette paid 200,000 pesos as partial payment to Dessa. Let's just assume it's Dessa kasi wala naman dito eh. Kasi dito na ngayon una sila nagkita ni Rochelle. So Lynette now went to see Rochelle to pay the balance, which is 4,800,000 pesos. But Rochelle didn't accept it, saying that the contract of sale entered between you and Dessa is void because it was not in writing. My contract or my agency to sell between myself and Dessa was not in writing. Ayan, so void and unenforceable daw yung sale. Okay. So the questions are, is the contract of sale void or unenforceable? And next, is Rochelle correct that she is not bound by the contract? Alright, so those are the questions in relation to that problem. So, yan. Isama nyo yan sa sagot nyo na i-email nyo sa akin. Again, it's ajumrani2000@gmail.com. Okay, last question. XYZ Bank was ordered by the Bangko Sentral ng Pilipinas to divest itself of real property investments so as to preserve its liquidity. However, most of these real properties were locations for XYZ Bank's branches. So XYZ Bank formed ABC Corporation and sold to this ABC Corporation the affected real properties. Simultaneously, ABC Corporation leased back the properties to XYZ Bank. But technically, it just happened all in paper, no? There was really no transfer of property. XYZ Bank stayed in these properties. Now, later, XYZ Bank never paid rent to ABC Corporation. So, several years later, ABC Corporation sued XYZ Bank for ejectment on the ground of non-payment of rent. XYZ Bank countered that there was an unwritten trust agreement between XYZ Bank and ABC Corporation, with the latter, ABC Corporation holding the properties in trust for the former XYZ Bank. Okay, so you have a bank which had properties way more than what was allowed for it to own. And the Bangko Sentral said, oh, medyo sobra na ang mga properties nyo, you had to divest yourself, sell them. Okay, so ang ginawa ni XYZ Bank, nagtayo siya ng ibang kumpanya, ABC Corporation, to transfer or to sell these properties to ABC Bank. But ABC Bank executed a contract of lease so that XYZ Bank can remain in the property. Later on, ABC Bank or ABC Corporation sued for ejectment. Sabi naman ni XYZ, you cannot sue me for ejectment because I own the property. You are merely a trustee. Okay, we had an unwritten, okay, because it was not executed as a separate or a distinct trust agreement, but rather they just had these two contracts, contract of sale and a lease contract. So sabi ni XYZ Bank, you're a trustee, we have an unwritten trust relationship over these real properties, so you cannot sue me for ejectment, bagkus kaya kitang idemanda for the recovery of the property. But then that's something else na. Okay, so the question is this: is the alleged trust agreement between XYZ Bank and ABC Corporation enforceable? Why? Ayan. And next, okay, by the way, tandaan nyo, pansinin yung tanong ha, pag sinabi natin enforceable, then check Article 1403 or any other law that requires a specific form, okay, or whether it should be in writing. Ayan. Kaya, alam mo yun, it's good to read the label. Okay, it's good to read the question. So ito, enforceability, wag nyo akong bibigyan ng sasabihin nyo sa akin na it's void because ganito, ganyan, it's against public policy. Doon mo sa second question yan sagutin kung totoo nga talagang this is against public policy, because in the second question, the question is with respect to the validity of the trust agreement, and applying the law on void contracts, pansin nyo, when is a contract void? It is void when the object or the cause is invalid or illegal. O kaya tingnan nyo yung grounds for void contracts if you want to answer this question. The second question, which is that, is the trust agreement valid and why? Yan. So ayun, so don't forget sa mga estudyante ko na, na nanonood ngayon, please send your answers, very short answers, basta short but comprehensive, to my email address ajumani2000@gmail.com, no later than 12 midnight tonight. Okay? Para at least wala na kiisipin bukas. So no later than 12 midnight tonight. Okay? So I'll be expecting your emails by 12 midnight. Late emails will not be accepted. Okay. Tingnan nga natin meron pa ba mga last landmark cases. Pwede na libro yung civil law YouTube slides niya. Okay, sayang di ko nasimulan. Pwede mo pa rin simulan to, Zutaben. Panoorin mo lang ulit pagka na-upload na siya. Tapos replay, ayan, may replay. Hindi po siya replay. Tawag ba? Yes, you can watch it again. So Blue Falcon, sir, past bar exams na lang at landmark cases, pwede na libro yung civil code law. Yes, oo nga. Pero sige na, kailangan pa nating pagtuunan ng pansin niya. So most probably I'll just make my book na lang in case I will have to add cases and discussion of past bar exams. So yeah, baby steps. And then in the meantime, my intention here is to just help you know, to be an added resource for bar reviewees and for students. I'm sure there are so many legal resources out there. We have very good books, very good authors, very good YouTube channels on the subject. So dagdag nyo lang to. I mean, diba, the more the merrier. Ayan. Okay. So I think I've covered everything. So I'd like to thank you all for watching. Now you can see on the screen my social media accounts. You can find me on Facebook. My Facebook page is Attorney Al Jumrani, and of course you're watching my YouTube channel. This is the House of Law. I thank you all for watching. I thank you all for the support, for watching my videos, and watch out for more videos. My plan is for next meeting, dahil nga civil law talaga ang area ko, so magsi-civil law na lang ako, and para pipilitan lang. Hindi kasi paminsan, di ba, para naman maiba naman tayo. Pero yeah, I plan on in the immediate future, and by immediate siguro in a few days. Ayan, in a few days I'm going to make a video about, kasi nga tapos na ako sa law on persons, di ba, yung background of the family code. So magpa-family code na tayo, pero mukhang marriage lang muna kasi nga hindi kaya ng entire 1 hour or 2 hours yung entire family code. So yung marriage muna, at saka para hindi kayo ma-data overload or information overload. Okay, so that's it from me. Thank you very much for watching. Please like if you enjoyed this video. Please subscribe if you haven't yet, and please click that notification bell so that you will be notified in case I upload a new video. So laging tatandaan, isip ay buksan, alamin ang batas. Bye!